Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. You may be seated. Good morning, everyone, and welcome to the Fourth Circuit Court of Appeals. And Judge Harris and I particularly want to thank Judge Cullen for joining us today. And with this panel, we have one case, and we're ready to hear argument in that case, Finley versus Kraft Heinz.
May it please the court, Judge Thacker, Judge Harris, Judge Cullen. My name is Thad Geyer from Medford, Oregon. I'm a contract lawyer for the Government Accountability Project, which is a whistleblower advocacy organization. They have assigned me to represent Mr. Finley here. This case actually begins with Paulsgraf v. Long Island Railroad Company. And that is because this is where Judge Cardoso, who later became Justice Cardoso.
Excuse me, it doesn't seem like your timer is moving.
Oh.
That's me.
We need it to move. Okay, go ahead.
Thank you. Causation. That's where Judge Cardoso, who then went on to become Justice Cardoso, basically rewrote the law of torts, and he had enough power and influence to be able to do that and influence what has been called since then an institution. But the idea was, he essentially said that at some point, the courts have to set a legal standard of causation apart from what the factual standards of causation are. And that's what we're here for today, because the Supreme Court basically said, we disagree with Justice Cardoso, and we disagree with this very idea of showing intent, this idea of this presumed causation.
And where is it you think the Supreme Court did that? Are you talking about Murray?
In Murray.
Okay, and where in Murray did the Supreme Court say all this?
Well, it's throughout the decision.
Okay.
Yeah.
And did that alter our Fourth Circuit precedent, Feldman?
Let me see. I would say that it doesn't alter the precedent, except to the extent that Feldman probably assumed the intent factor was there, because Feldman drew so heavily on McDonnell Douglas, and that's where all of that has to do with intent.
Well, in Feldman, we said that the contributing factor element is, quote, broad and forgiving. You probably like that, right?
That's part of what I loved about the case.
Okay, and so how is that applicable to the facts here?
It's the same applicability to the facts here, but there's a couple of distinctions here, very important distinctions. Number one, this is a Food Safety Modernization Act case. That means a lot to this panel, because the panel, of course, is not allowed to overrule any other panel or to make any major modifications. So Feldman is not a Food Safety Modernization Act case, so it's kind of analogous, but you aren't bound
But it's a substantial factor causation case, right? I don't understand why would it make a difference? Is there something about this particular statute that is is relevantly different from the statute in Feldman?
No.
Okay.
The statutes are the same. It's just that the understanding, the context, in terms of the rule of law, changed radically with the unanimous Supreme Court case in Murray v. UPS.
I feel like I am just missing something I want you to explain to me. I thought the court in Murray held that you don't have to show retaliatory animus to make out a substantial factor causation case, but I didn't understand either the magistrate judge or the district court in this case, or indeed your colleague on the other side, anyone to be talking about a requirement of animus.
It was not spoke of openly, but so that the court didn't come to that point. But that was essentially the context of what the court did.
No, it wasn't. I thought like the animus cases are where someone is being sexually harassed at work and the boss says, you might be happier, and complains, and the boss says, well, you know what, I think you'd be happier somewhere else. And then the defense would be, I wasn't angry, I was just trying to do what was best for the employee. So there was no animus. There was causation, but not animus. But I just don't see how that applies at all to the facts in this case.
Because I think it's important to be able to understand what contributing factor is. You have to get to the point where if intent is not required, then any kind of causation that assumes intent also is not required. And that gets you to causation, and that is the case that I cited for you with what happened with Murray v. UBS on remand. We're now awaiting whether or not the en banc is going to be granted or not. But it went back down to the same panel. And as the dissenting judge said, is you have to take your lumps. You can't just blow the Supreme Court off and then essentially try to write intent in by saying the contributing factor is causation. That's a very big thing, because if contributing factor requires causation, it almost necessarily involves intent, because you can't think of what contributing factor is without intent.
Yes, you can. It is literally the example I just gave you. You're being sexually harassed, you complain about it, your boss, in an effort to help you, switches you to a different department. The complaint was obviously a contributing factor. He moved you because you complained. But the defense used to be before Murray, but no animus. I wasn't angry. I encourage people to complain. That's what Murray's about. I don't understand the company in this case to be saying, yes, we fired him because of his complaints, but we really wished him the best. We weren't angry. It's not that kind of case.
This is it. Well, I agree with that in that sense. And that's the example you just gave is Marano versus Department of Justice, which was cited by the Supreme Court in Murray v. UBS. And in the Marano case, if I could just briefly, because it's such an important case, in the Marano case, Mr. Marano had made complaints that the DEA office he was up in Albany, New York, was so mismanaged that something had to be done. And as a result of that, an investigation was conducted, and by a whole different set of decision makers, and those decision makers said he's absolutely right, it's a terrible office, and we're going to start doing some reassignments, and he was reassigned. And in that case, the Federal Circuit held that that is contributing factor. So all that it takes is any contributing factor.
Well, what do you want us to do with the intervening factor here? I mean, there are the complaints, the alleged protected activity, and then the firing. But in between that, there's all of his dishonesty, which is the reason that he was terminated, according to the company.
Right.
You just want us to ignore that intervening part?
Yes, you have to ignore that intervening
We have
part.
to just ignore that, so he could just repeatedly lie
He
and
could
shift his
repeatedly
story,
lie.
and they can't fire him.
Absolutely, they can fire him.
They
But they are
can.
going to have to but that has no effect on contributing factor. Contributing factor
It's the
is
reason-
uninfluenced by what the employer's reasons are, the causes that they give. And so the way the statute is set up, and it's very important how it's structured, is once he shows any contributing factor whatsoever, the company could still get rid of him and say, it's because you're a liar. But they have to prove that by clear and convincing evidence.
Okay, right. And so if we find that there is clear and convincing evidence here that that's the reason they fired him, or that the district court found that, then it does make a difference.
Well, to the extent that you're willing to say that the district court made any kind of finding on clear and convincing evidence, which it most certainly did not, all the district judge did was adopt essentially a footnote or two from the magistrate. But there's no credible discussion for this court
But you
to
do
accept.
concede that he changed his story several times.
Yes, but not from dishonesty, from confusion. And that gets you to the Tolman versus Cotton case, a Supreme Court case in 2014. This is like an unsung hero of summary judgment. And it was one where the Supreme Court took that on in 2014 and said, we're going to take this on just because the district court and the Fifth Circuit and other judges are out of control on this. They are defining these contexts. And in these contexts that they build, these big pictures, this idea of what really happened there, they are
I don't think anybody should be couching judges as out of control. You may disagree with them, but I don't know I don't know why you need to say that, but go ahead.
Well, then forgive me on that.
So, Mr. Geiger, let me ask you, insofar as we don't agree with you that Murray abrogated legitimate intervening event, let's talk about, I mean, you point out that there are myriad genuine issues of material fact, and the investigation itself was flawed from start to finish, and you make the argument that Bobby Clark should be a comparator. Kraft says, no, he's not, because he's not accused of dishonesty. But if you look at the record, I think you have an argument that Bobby Clark is a comparator, and perhaps he was as dishonest insofar as Mr. Finley was dishonest as Mr. Finley. As I read the record, Bobby Clark, the day before he was supposed to fire Ms. Gaines, said, I fired 3 out of 4. I'll take care of firing Ms. Gaines when I get back to work. Ms. Gaines comes back to work 10 days later. She shows up, and when Bobby Clark is interviewed, he immediately points the finger at Mr. Finley and says he was supposed to have fired her and walked her out. So there's a direct contradiction, and the company didn't do anything to get to the bottom of Bobby Clark and his role in this thing when, as I read it, in the light most favorable to you, he's probably more dishonest than Mr. Finley.
That may very well be the case, and certainly that's my view of it. And as you kind of introduced it, this really falls under the rubric of what the investigation was like and what they were really looking at in this case. The difference, and we point this out, this is undisputed evidence, the difference is Bobby Clark is not a whistleblower. Mr. Finley is a whistleblower, and therefore we have that. I do want to get back to Tolman, but yes, Judge.
No, go ahead. Okay,
just on Tolman, and this has to do with whether or not this is what is dishonesty or confusion, or just trying to remember. What in Tolman happened is the district court and the Fifth Circuit had said that Mr. Tolman started screaming and threatening the cops, and he was loud, and the cops were afraid, and the cops said we were afraid. And what the Supreme Court said is a jury, however, could find that he's screaming and yelling because he's worried about his mother. And that just because someone is screaming and yelling and saying, stop doing this, and stands up at the same time when the cops tell him to sit there and say, get off of my mother, the Supreme Court said that goes to a jury. And that's exactly what we have here, is what happened with whether or not Mr. Finley was confused or lying, that goes to a jury.
What goes to a jury is whether he was confused or lying, or is what goes to a jury whether his employer believed he was lying and not confused?
Absolutely not. What the employer believed has nothing to do with this case, because it doesn't have anything to do with the contributing factor standard. And that is because this idea, this honest belief of the employer, this comes from the olden days. This is McDonnell Douglas stuff, having to do with causation and intent of the employer. And the idea was that when an employer simply had to articulate a reason for getting rid of the employee, because the employee is trying to make this prima facie case, all they had to do is articulate a reason. And the reason was because he was terrible this way, this way, this way. And that is where the court said, if you don't have more than that, and you just want to say, but he was a good employee, he never did these things, the court said that was not enough. Has nothing to do with this case. Additionally, I want to point out that Kraft Heinz does not assert the honest belief doctrine, which is very fascinating. They make an argument, but they stop short of being able to do that. So that has nothing to do with the case, in my opinion. I'll save a couple of minutes.
All right, thank you. Ms. Williams, go ahead.
May it please the court, Caitlin Williams, on behalf of defendant appellee Kraft Heinz Foods Company. Kraft Heinz terminated Mr. Finley's employment solely because it found that he was dishonest in violation of company policy. That finding of dishonesty was based on Mr. Finley's internally inconsistent statements about his involvement in the discharge process of another employee named Yolanda Gaines. In the span of one day, March 24th, 2020, Mr. Finley gave Kraft Heinz conflicting versions about his own involvement in that process of discharging Ms. Gaines.
Ms. Williams, how did Mr. Finley become the target of the investigation on March 24th? I mean, it's undisputed that Mr. Clark was a direct supervisor. He testified in his deposition that it was solely his responsibility to terminate Ms. Gaines. Other employees testified that supervisors like Mr. Clark were supposed to do that. And Mr. Clark himself told Mr. Finley in the presence of another witness whose declaration is in the record that he, Mr. Clark, was responsible for doing that. And then when this lady shows back up at work, all of a sudden Mr. Clark is pointing the finger at Mr. Finley. So it seems to me Mr. Clark is most culpable for this fiasco, this employee getting back in the building, and yet he emerges completely unscathed in this. So why is that, and why isn't he a proper comparator? When in the light most favorable to the plaintiff, I think he is, there's a credible question as to whether he was completely forthcoming and honest with HR.
Judge Cullen, thank you for that question, and I did want to address the concerns that you raised with Mr. Clark as a comparator. I would like to just respectfully add one piece of Mr. Clark's deposition testimony that would negate the notion that he said he was solely responsible. He did go on to say that the task would go to his boss, and I believe that the district court noted that additional testimony from Mr. Clark. So,
And do you know where that is in the JA, the additional testimony that you're highlighting?
I will have to find the JA site for you, but
We can find it.
It is where he elaborates that in Mr. Clark's absence, the task would go to his boss.
In his absence, okay, and was
Correct.
that the key, that Mr. Clark was absent when the
Indeed-
fired employee returned?
Indeed, Mr. Clark was absent on the day the fired employee was supposed to be walked out. That's March 12th. He then was on a period of vacation and was not there when she did start returning to the building.
I couldn't figure that out from the record. How
Yeah.
long was he on vacation?
I believe it was certainly the following day, which would be Friday, and then I don't think it is clear in the record how many days the following week he was there. But I don't think it's a material dispute as to whether Mr. Clark and or Mr. Finley witnessed Ms. Gaines continuing to come to work, because that was not the reason for Kraft Heinz's discharge of Mr. Finley. To answer your question as to how this all kicked off and got going into Mr. Finley's direction from the company's perspective, when it became known to Ms. Perry, who's an HR representative, that Ms. Gaines had entered the building incorrectly, she started her process of endeavoring to find out why. Through that process, it was identified that Mr. Finley and Mr. Clark had both signed Ms. Gaines' termination form. There was a hashing out of what went on, and in that hashing out, Mr. Clark, unlike Mr. Finley, was consistent in what he told Ms. Perry. And that is how the idea of following up with Mr. Finley distinguishes itself from the lack of follow-up with Mr. Clark. Because on that crucial day of March 24th, 2020, from the perception of the Kraft Heinz decision makers, Mr. Clark remained consistent, Mr. Finley did not.
But he contradicted himself, because we know from Jesse Tracy and Mr. Finley that Mr. Clark told them on March 12th that he would take care of this when he returned to work.
But the question is not whether he didn't take care of it when he returned to work. The question is, what did he say to Maya Perry, to answer your question, that put the light on Mr. Finley? And from there, the material facts are that Mr. Finley gave Kraft Heinz conflicting accounts of his involvement. So at that point, on March 24th, 2020, the knowledge in Kraft Heinz decision makers' minds is that he's not telling a straight story.
But he never said he walked her out, correct?
He did tell Ms. Perry initially on March 24th, 2020, both that he walked her out and that he turned in her termination.
He denies that, though.
He denies that, and he denied it to Kraft Heinz later in that same day, which is why Kraft Heinz believed that he was being inconsistent. And so I would urge the court to focus on the perception of the Kraft Heinz decision makers on March 24th, 2020. It was indeed Mr. Finley's conflicting accounts, I walked her out, no, I didn't walk her out, that led them to the conclusion that he was being dishonest. And that is a crucial distinction from the company's perspective from Mr. Clark, who was consistent that day with Ms. Perry. So looking to the perception of those decision makers, Mr. Clark was not a comparator. More to the point of the contributing factor question that Mr. Finley's counsel makes much ado about, there was no other factor besides Kraft Heinz's conclusion that Mr. Finley was dishonest that contributed to the termination of his employment. Feldman is on all fours here. The district court properly applied the contributing factor standard by asking, did Mr. Finley's alleged protected activity contribute, i.e. tend to affect Kraft Heinz's decision to terminate his employment? Assuming arguendo that he engaged in protected activity under the FSMA, the Food Safety Modernization Act, the court correctly found that he did not. And ultimately, that's because Mr. Finley has brought to the table only his own speculation as to a connection between his alleged protected activity and his termination of employment.
Well, let me ask you about temporal proximity, because in the light most favorable to the plaintiff, he was engaging in protected activity, and I know you're not conceding that, as late as March 12th. And we know that because when he sat down in that recorded interview with Josh Harp's trying to orient him, and he says, you would, remember it was that day, you would come to me complaining about the blast attendance. Mm-hmm. It doesn't get any closer than that in terms of temporal proximity. I've never seen a case where it's within days. Doesn't that cut against Kraft's position in terms of contributing factor? I mean, that's in my mind, a determinative factor. It went on until March 12th.
Judge, thank you for that question. Temporal proximity is a relevant question when you're looking at contributing factor, as is legitimate intervening event. On the temporal proximity piece, we dispute that Mr. Finley engaged in protected activity on March 12th, not only because of our FSMA-based arguments, but because simply having Josh Harp's reorientation of him and coming from his prior statement 12 days earlier that he needed a blast attendant. Saying that you need a blast attendant, number one, is not protected activity. But number two, Mr. Finley did not raise that allegation of protected activity until his summary judgment opposition brief. So it is not properly before the district court as an argument as to a contributing factor into his termination.
Counsel, am I remembering right? Is this the objection that Mr. Finley raised that the district court never passes on? Because the district court says it doesn't matter. The magistrate thought it was enough temporal proximity, even if the latest one was in February. I'm concerned that the district court never ruled on this, and if we think about intervening event, not as an on-off switch, but as something that might weaken the inference from temporal proximity, then it actually really does matter how temporally proximate these two things were. Do you see what I'm saying?
I believe so, and tell me if this answers your question. Absolutely, temporal proximity is a factor. If we just, for argument's sake, assume that he engaged in protected activity under the FSMA on March 12th, the intervening event here on March 24th, 2020, I would argue is not just weakening the inference of causation, it is dispelling it completely. And the reason I say that is in part because even Mr. Finley concedes that his trajectory at work changed as a result of the Miss Gaines investigation. After March 12th, but before March 24th, 2020, Mr. Harp, Mr. Finley's supervisor, gave him additional responsibility for a new department. And Mr. Finley was excited about that. That suggests to me that this isn't just a
It
weakening.
might suggest that to you, but the question is what might a jury infer from this series of events, right? A jury might suggest something other to a jury. It might suggest to a jury that they were really mad about this protected activity and they waited for the first decent opportunity to do something about it, which was when this whole Gaines thing came up, and then they were like, great, this is our moment.
I hear you. I don't believe that a reasonable juror would infer that from the facts. And I say that because it is simply not reasonable to leap from a March 12th very vague reference to Miss Perry about a blast attendant. Miss Perry did not make the decision to terminate Mr. Finley's employment. After that, a decision maker in Mr. Finley's termination, Mr. Harp, gives him additional responsibility. That does not suggest he's going anywhere. After that, the Gaines investigation kicks off solely because Ms. Gaines showed up to work and Human Resources had deactivated her badge, leading to the questions and the hash out that we were discussing earlier, in which Mr. Finley made inconsistent statements. And I don't think the record permits a justifiable inference that if not for the Gaines investigation and Mr. Finley's contradictory statements during it, he would have been terminated on March 26, 2020. There were other opportunities prior to that date, and Kraft Heinz, to your question of, is this the first moment? No, it was not the first moment. This was a sequence of events that had nothing to do with anything other than Ms. Gaines showing up to work and the subsequent events that followed. There's no evidence in the record that Kraft Heinz took advantage of the situation.
I think you were about to say there were other opportunities where they, I guess, could have terminated him before they finally
For example,
did.
Yes, for example, Mr. Finley brings up his March 26th management reviews that were positive. Those postdate much of his alleged protected activity. So I would also say that when we are contrasting the evidence as to what Kraft Heinz put forth regarding the consistency of the decision makers' testimony regarding their basis for termination, on the other side of the ledger, we have quite a few concessions from Mr. Finley that do not hold a candle to the objective evidence of the consistent decision makers.
Can I just ask you a question that will help orient me a little
Yes.
bit? Are we talking here about whether Mr. Finley made his prima facie case? Because I thought the magistrate judge said you didn't even make a prima facie case here. Or are we talking about what happens if he did, and now it's the defendant's burden to show that they would have done the same thing?
Yes, we're really talking about both in a sense, because Kraft Heinz's evidence as to the reason for its termination of Mr. Finley bears both on the contributing factor element of his prima facie case, and it's the evidence that the district court relied on in finding that he had not satisfied that burden. It also bears upon Kraft Heinz's ability to show by clear and convincing evidence that it would have taken the same action with respect to Mr. Finley in the absence of the alleged protected
Right. I found that
activity.
overlap somewhat confusing in this case. And when the magistrate judge says at the prima facie step, and it's part of that analysis, look, there's a legitimate intervening event, and that severs causation. I thought that was overstating it quite a bit, that an intervening event might weaken the inferences you could draw from temporal proximity, but I don't think we've ever said it makes it impossible to show causation. And so I'm a little nervous that there was some mixing of standards here.
Thank you, Your Honor. I don't believe that the judge suggested that it was automatically severed just because the presence of a legitimate
Well,
intervening.
that's what the magistrate judge said, but you think there was something else going on?
I do think the magistrate and the district court relied on the consistent evidence from Kraft Heinz as to the reason to Mr. Finley's termination. So insofar as he inspected and interrogated the record supported that the legitimate intervening event was the only reason for the termination. And by virtue of that, the contributing factor standard has not been met. I would say that this court in Feldman and Barrick look at whether the legitimate intervening event rationale applies at that contributing factor stage of the case, and have in those cases found that at that stage a legitimate intervening event can disrupt any inference. My point that I hopefully made is that the same evidence can support both the lack of a contributing factor as well as the ability to establish the clear and convincing affirmative defense. I don't think the district court mistook the burdens. I think they used the same evidence at both stages of the case.
But the magistrate judge, he addressed the affirmative defense in a footnote and said, essentially for the same reasons I find no contributing factor, I would find that you have established by clear and convincing evidence. The district court didn't engage on that issue at all. So don't we, perhaps as a minimum, have to remand it to have somebody address the affirmative defense, even if we agree with you?
I don't think if you agree with me, you need to remand, because the record is fully developed and this court can decide on the record that the parties have presented, regardless of whether the district court gave it the analysis that your honors would. And so
But the district court just got the causation standard wrong, right? Didn't the district court say this is a McDonnell Douglas case?
thank you for bringing that up, because I do want to make a point of clarification on that. The magistrate judge absolutely correctly articulated the burden shifting that applies to the FSMA, relying on Feldman and that standard that Your Honor recited earlier. The district court adopted and incorporated in full the magistrate's report, including that burden shifting analysis. The district court also adopted the magistrate, and when I say district court, Judge Kane adopted the magistrate judge's finding that no reasonable juror could find a contributing factor. The district court, in reciting kind of an introductory remark as to the law of, that's applicable to burdens, did cite an FMLA case, Nichols. That does not articulate the standard, as well as Feldman, as well as Barrick, as well as Burton, the FSMA case in the Western District of Tennessee. And so I do think there's a point of clarification that can be made on the articulation. However, reading Judge Kane's opinion, there is no indication that he held Mr. Finley to a higher standard than is applicable under Feldman and the contributing factor analysis. In fact, he notes that neither party objected to the magistrate's articulation and application of the standard, and his opinion, the heart of it just went on to address the objections that Mr. Finley had raised. And so there was no reason to go further into the burden shifting, because it wasn't something Mr. Finley had objected to. Do you have a question, Judge?
I do. In terms, I think you said that most of, insofar as he engaged in protective activity, it occurred before his last performance evaluation. Is that what you said?
I said much of it occurred before his February 6th of 2020 performance review.
All right. Well, as I read the record, and this is Mr. Finley corroborated by two of his co-employees, I mean, he was making regular complaints that went as far as to taking a package of bacon up to the supervisor's office, opening up, and then essentially suggesting they needed to shut down the entire line. He was complaining at morning meetings about the lack of calibration on the x-ray machines, and they're not being utilized properly. And that was occurring, based on my reading, in February into March, right, in terms of temporal proximity. Under a contributing factor standard, that's particularly powerful evidence that I think could persuade a jury, right? Don't those create genuine issues of material fact here that factor into that calculus, and ultimately a jury needs to weigh that?
I disagree, Judge, and I say that again because of the timing of the legitimate intervening event being Ms. Gaines' termination, compounded with the fact that the only record evidence as to why Mr. Finley was terminated is his dishonesty. That evidence is rooted in the record. It is rooted in the case law that contributing factor and legitimate intervening event occur at the same stage of the analysis. And by contrast, what Mr. Finley suggests is the connection between his alleged protected activity and the termination is sheer speculation. He concedes that two of the key decision makers, Mr. Harp and Ms. Wilson, it was their opinion that he was dishonest. He couldn't disagree with that conclusion. He concedes that the third key decision maker, Ms. Longerbeam, was unaware of his alleged protected activity. And under those facts, it's not enough to go to a jury on one side having an employee speculation and on the other side having this consistent decision maker testimony. On that same point, the individuals who Mr. Finley raised with respect to him going to the office admitted, if you look at their full testimony, Ms. Debrick is who I'm referring to, that she heard from those decision makers that Mr. Finley was terminated because of his dishonesty. Her rumors are inadmissible hearsay, and that is not enough to withstand summary judgment.
Can I just, so I guess when I think about this case and the substantial factor causation standard, sort of, it seems to me that a jury maybe could really think, even if the company thought he had been dishonest in some like quickly cleared up minor way about what seems to be a fairly minor incident anyway, like it still might have made a difference when they decided they were going to fire him for this, that they were already kind of sick of all the complaints. I mean, that, like, is there some reason why this seemed like such a big deal to the company? And do we know that they fired other people for this kind of dishonesty? I mean, I know that the company put in evidence that they had fired other employees for like falsification and dishonesty, but I can't tell, like, maybe that was someone falsified a safety report versus like when someone comes into the kitchen and says, who left their lunch here? It stinks. Somebody says it wasn't me. And then 5 minutes later, they're like, okay, you got me. It was me. Like, I feel like this just seems so trivial. Why would someone get fired for this?
I would disagree that it's trivial, and I would point you to the perception of Ms. Wilson particularly, as well as Ms. Longerbeam, who are seeking to apply Kraft Heinz's company policy, which prohibits dishonesty. And their conclusion that he was dishonest, again, Ms. Longerbeam having no knowledge of his protected activity, and they're behaving consistently with how they have done in the past.
But
We're
we
not
don't know
aware of a similar, to answer your question, we're not
Yeah.
aware of a similar sequence of events where you have, in the course of an investigation, an employee giving conflicting answers. But that is not trivial in the honestly held belief of Kraft Heinz's decision makers. And on that final point, with my remaining time, I would just want to point out that Mr. Finley's
Well,
counsel.
how long was it that this employee had access to the building when she should not have?
It was it was 11 days that she had access to the building.
Well, that's part of what, at least I would think you would think makes it not trivial, that someone who should not have had access to the building did have access to the building for 13 days, and he was sort of a part of that.
Indeed, and the record shows that, I believe it was Ms. Perry who recommended that the security guard, who's not a Kraft Heinz employee, but nonetheless that person be removed from her assignment because of her dishonesty in the situation in which Ms. Gaines was permitted to come into the plant improperly. I'm seeing my clock go up, so if I may continue.
Well, your time is actually up, so you can make
I'm sorry.
Yeah, it's confusing.
Thank
If
you for
have
letting me
anything you wanna
answer that
close-
final question in that event, and thank you for your counsel.
All right, thank you. All right. You have 5 minutes in rebuttal.
I have 5 minutes.
Uh-huh.
Thank you so much. Whether or not it's a trivial point, what happens with Ms. Gaines, what we do know is that her direct supervisor, Bobby Clark, sees her there all those days after he comes back from vacation. He only takes a couple of days off vacation time, and comes back. Doesn't think a thing about it, doesn't report it to anybody. Their whole computer system doesn't even know that she's there. She's clocking in and clocking out. They have no system at all for that. And I think that when you look at that, you really wonder where the trouble is going to go on this. And maybe the security guard is not a comparator. But I say that she is a comparator, but they say, well, she's a contract employee, because they buzzed her through. Anyway, here's the point. The biggest point that I could make is contributing factor is a bell once rung cannot be unrung. It cannot be unrung once it's rung. And so when you have it can be overwhelmed by clear and convincing evidence on the defense. But where you have on page 19 of the brief, as you referenced, Judge Collin, where Mr. Harp, the direct supervisor, says to this befuddled Mr. Finley, just struggling to try to remember what had happened. Mr. Harp says, do you remember? I know, but that day, do you remember going in and out of HR office a lot? They mentioned that. You're in there, but it was a little more frequent. And it was about the blast attendant. It was about the terms. It was about, and then Mr. Finley says, see, I forgot about there even being about the blast attendant. And then points out, I then came back and talked to you about it. This blast attendant, this is the main thing, because this is the main way the public is protected from breaking their teeth or choking to death on these things that go out the door. The stakes are very hard. So that's either a contributing factor or not. Once it's a contributing factor, that's the bell. It doesn't get unrung after that. I say it's the same thing with time proximity. Once you have Once you have this protected activity in a close proximity of time, that's enough to establish your prima facie case. That's the bell that is rung. You cannot ever undo that time proximity. You can simply put on your case by clear and convincing evidence that you would have gotten rid of him anyway. No volume of evidence of how bad he was, and that's why I said before, it doesn't matter if he's the biggest liar in the world. No volume of evidence can undo the contributing factor, and that's how Congress decided to do it. And Congress said that once we do that, we basically go into a whole new system, essentially unknown to the at-will regime. We're basically in Europe now, where the employer has to make it for cause, except it's Europe supercharged, because you have to make it for cause, clear and convincing evidence. Why? Because Congress wants to know about when airplanes are unsafe, when food is unsafe, when nuclear power plants are representing danger, when there's going to be pipeline spills, etc. That's what Congress said. We are willing to rewrite the system of accountability in the workplace if that is going to get us what we need, which is information so that we can protect the public. Thank you very much.
All right, thank you for your arguments. We'll come down and greet counsel, then we're going to go conference this case and reconstitute the panel and have a short recess.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, thank you. You may be seated. All right, and we have 3 cases remaining. We're ready to hear Burrell versus Shirley.
Good morning, Your Honor. Erica Hashimoto, Director of Georgetown Law's Appellate Litigation Clinic. With the court's permission and Mr. Burrell's consent, third-year law student Asha Rajani from the clinic will be presenting argument on behalf of Mr. Burrell.
Great, thank you.
Good morning, Your Honors, and may it please the court. This court should reverse the district court's order denying Mr. Burrell IFP status in this case because the 3 strikes rule under the Prison Litigation Reform Act does not apply to him. 2 of his 3 prior dismissals should not have counted as strikes under Section 1915G, which states that only dismissals for frivolity, malice, or failure to state a claim are strikes. The dismissal of Burrell v. Unknown on younger abstention grounds is not a strike, and the dismissal of Burrell v. Anderson on Rule 41B grounds is also not a strike. I will first discuss Burrell v. Unknown. The dismissal of Burrell v. Unknown is not a strike for 2 reasons. First, a dismissal on younger abstention grounds is not a dismissal for failure to state a claim under the PLRA. The district court, in deciding whether the younger abstention doctrine applies, does not analyze whether all of the elements of a cause
Do
of
we
action...
have to agree with you on all of these strikes or just one?
You'd only have to agree with us on one to allow Mr. Burrell to proceed IFP, but we request the court to decide on both issues because Mr. Burrell would still be harmed if you decided on one because he would have an additional strike on the record, Your Honor.
I'm sorry, can I ask you one other question about the posture of this case? If we agreed with you as to one or both, what would we do exactly? I take it we would approve Mr. Burrell's motion to proceed on appeal, IFP?
That's correct.
Right.
You would essentially say that the 2 strikes, one dismissal on younger abstention grounds and the dismissal on 41B, if you
Right, okay.
choose to decide, are not strikes.
Right, but I'm trying to figure out what would follow from that. So we would approve the motion to proceed, IFP. Then what? Is there appeal? Is there an appeal? Do we let him appeal the district court order, or do we dispense? Right, there's an appeal, and there's also a motion to proceed, IFP. And I'm just trying to figure out, assuming hypothetically, sorry, I'm kind of starting at the end, but since we were talking about the posture of this case, if we agreed with you, is the only thing in front of us this motion by Mr. Burrell to proceed before us, IFP, or do we also have the appeal in front of us to decide? It's a little confusing.
Right. The appeal is to appeal the denial of IFP status.
Right, so we could decide that too?
Yes, and so that would allow him to proceed IFP
In the district court.
I'm sorry,
in
go
the
ahead.
in the district court.
You want us to so you want us to do 2 things, basically. Approve his petition to appear before us, IFP, and you want us to vacate the district court decision and say he can proceed IFP in the district court.
Yes, to proceed IFP, which allows him to proceed forward in the district court with this case, IFP.
Do we have to go quite that far? Isn't the actual issue before us whether the district court erred in counting the Unknown case and the Anderson case as strikes? And if we were to agree with one or both of those, we could vacate on those grounds or reverse on those grounds. But doesn't the statute give the district court some discretion about IFP that is not before us? In other words, shouldn't we just limit our ruling to the errors you are appealing as opposed to declaring him entitled to IFP status?
That is correct. If you rule that the that both dismissal on younger abstention grounds and dismissal on 41B grounds are not strikes under the PLRA. That would be our request.
Then he can, the district court can do whatever with
That's
those
exactly right.
determinations in hand.
That's exactly right, Your Honor. So I will first discuss Burrell v. Unknown. The dismissal of Burrell v. Unknown, as I mentioned before, is not a strike for two reasons. First is because the dismissal on younger abstention grounds is not a dismissal for failure to state a claim. This court's holding in Brunson v. Stein supports our position. In Brunson, the court
And so does the district court, right? Didn't the district court say that if it was sent back, the district court would find that that one wasn't a strike? I mean, that's why opposing counsel's here, I think.
So the way that we're using Brunson is that Brunson clarified the process for whether an action should be dismissed for failure to state a claim. And we believe that that process doesn't apply to the younger abstention grounds because the court is not looking at whether all of the elements of a cause of action are present.
Can I, so your argument is that a younger abstention is not a dismissal for failure to state a claim. Can I ask you a question about the way these statutes fit together? So it's not, you would say that under subsection G, it is not a dismissal for failure to state a claim. But under the screening provision, section 1915A, that authorizes a district court to dismiss a case without docketing, without serving the defendant on those same three grounds, if it's frivolous, malicious, or fails to state a claim. So my question is, if a younger dismissal is not a dismissal for failure to state a claim, is that going to be a problem under section 1915A? Does that mean that a district court can't, would have to serve the defendant and have a whole case rather than just dismissing it kind of sua sponte and without docketing the case under 1915A? Do you know what I mean?
Yeah, I understand what you're saying, Your Honor. Essentially, the failure to state a claim under the PLRA and the 12b6 standard under for failure to state a claim are the same sort of standard. I think the only difference is the timing of when the court would dismiss. And so for 1915A, it would be in the screening process before or right after it is docketed.
But what is the district court's authority to sua sponte dismiss under 1915A before docketing, before serving the defendant, if it is not, in fact, failure to state a claim?
That is one of the reasons given in the statute.
Right, but you're telling me a younger dismissal is not dismissal for failure to state a claim. So what under 1915A would authorize the district court to use this summary procedure on a younger abstention case? Or are you saying if it's younger abstention, yeah, serve the defendant, let the defendant plead it, and then,
If it's a younger abstention, the court is mandated to abstain.
You should go on with your argument. Thank you. I'm sure I'm not being clear.
As this court stated in Nivens, the younger abstention doctrine mandates that federal courts abstain from exercising jurisdiction and interfering in pending state criminal proceedings. The second ground upon which we think a dismissal of Burrell v. Unknown is not a strike is because Mr. Burrell's letter to the court should never have been construed as a legal complaint to begin with. Mr. Burrell's letter to the court, in which he described what was happening in his state criminal case, lacked all of the characteristics of a complaint. There were no defendants or claims listed. There was no request for relief. And Mr. Burrell neither paid court fees nor requested IFP status. We do agree with amicus that courts should liberally construe a pro se litigant's pleadings, but they should do so to help the litigant and not to harm them. What the district court did here essentially is treat Mr. Burrell's letter as a complaint to then dismiss it, and that.
But that's kind of an interesting way of looking at the liberal construction rule, that we don't do it if it would have a negative consequence, and we do it if it would have a positive consequence. I mean, if we weren't talking a three-strike question, you know, imagine it was dismissed because this doesn't have the hallmarks of a complaint. Would you say we should construe it liberally for that purpose, but not in the three strikes context?
The district court should liberally construe a letter as a complaint. All we're asking is that the district court then give notice to the litigant that they're going to do so. And perhaps allow the litigant an opportunity to let the court know whether they would like the letter to be counted as a legal complaint. If your honors have no further questions on the dismissal on younger abstention grounds, I wanted to move us to Burrell v. Anderson and the dismissal on Rule 41B grounds. A dismissal on Rule 41B is also categorically not a dismissal for failure to state a claim. The district court in Burrell v. Anderson applied the Atkinson factors in its final dismissal order to dismiss for noncompliance with a court order, which the Fourth Circuit affirmed as a 41B dismissal. Rule 41B is not an enumerated grounds under Section 1915G. Further, a Rule 41B dismissal for failure to prosecute or comply with a court order and a 12B6 dismissal for failure to state a claim are two distinct dismissals.
Well, they are, but if the district court has indicated that the complaint as filed doesn't state a claim for which relief can be granted and gives authority to amend, and the plaintiff doesn't do anything, we're not talking about just a failure to prosecute generally. We're talking about the failure to prosecute that builds off a finding of inadequacy of the pleadings. And so the cases that, you know, talk about failure to prosecute, generally, I think aren't really right on point because we got additional facts. Why wouldn't we consider this? Why wouldn't we look at the totality of the district court's rulings, which do seem to hit the Act's requirements, and the plaintiff here just failed to take the opportunity to fix them?
Right. Your Honor, yes, the district court in Burrell v. Anderson did give Mr. Burrell several opportunities and eventually dismissed on Rule 41B grounds because he missed the 30-day timeline to submit the third amended complaint. The district court could have dismissed on 12B6 grounds, but it chose to dismiss on Rule 41B grounds, and in their dismissal, they stated that had the plaintiff timely complied with the order, this case would have proceeded. Had the plaintiff requested additional time to comply, the court likely would have granted it.
But if the complaint is subject to a 12B6 dismissal for failure to state a claim, and if that had happened, there would be a qualifying strike, and the district court says, look, as pled, you're going to get, I'm going to dismiss your case on 12B6, but I'll give you a chance to fix it, and you don't take that chance up, I just can't understand why that wouldn't be a strike.
A subsequent district order that's assessing previous district court dismissal orders would look at the face of the dismissal order.
You would just say we just look straight at the last order, it's Rule 41, and we don't consider the context from which it arose?
Yes, Your Honor. This court has previously held in Blakely that the district court should look at what the face of the order, the last dismissal order states, and then see if that aligns with the language in Section 1915G. The district court here dismissed on Rule 41B grounds, which is reviewed on abuse of discretion. This is an involuntary procedural dismissal that's reviewed on abuse of discretion, whereas a 12B6 dismissal is reviewed de novo. So the district court use its discretion and its power to manage its own docket to dismiss on Rule 41B grounds.
Counsel, is there a little bit of tension in your argument or not? On this one, you're saying, just look at the face of it. It says 41B, that's where the inquiry ends. But on the first one, the younger one, the district court said, I'm dismissing for failure to state a claim under 1915A. But you want us to go behind that and look at what, come on, what was he really doing? So how do I make sense of these two arguments together?
We don't believe there's tension between our two arguments, Your Honor. We're asking that the district court review, a subsequent district court review the face of the final dismissal order. For Burrell v. Unknown, the court stated, for these reasons, the court must adhere to the abstention doctrine and the complaint will be dismissed pursuant to section 1915AB2 for failure to state a claim. The district court is making a legal determination that we think is wrong and that is reviewable by this court. As the court reviewed the district court's statement in Brunson v. Stein by saying heck dismissals are for failure to state a claim.
So when a district court, just take it out of the PLRA context, when a district court dismisses for younger abstention, if they're not under 12B6, what are they under?
We would say they don't fall under any of the 12B rules. The closest is 12B1, and other circuit courts, for example, the Ninth Circuit and the 10th Circuit has said that a dismissal on younger abstention is most comparable or akin to a 12B1 dismissal. And even in Nivens v. Gilchrist, the district court in that case also dismissed on 12B1 in this circuit as well.
Do you have a case where a factually similar case, not just a Rule 41 on its own? Assume I think we ought to look a little bit broader than just at the last order. We ought to look at the context from which it came. Do you have a case procedurally on all fours that helps you? I know there's a Ninth Circuit case that's contrary to your position, and I didn't see another case like this except for that Ninth Circuit case.
No, Your Honor, we don't have a case that specifically addresses whether Rule 41B is a strike under the
Can I ask you another question?
Yes.
That's outside of the briefs, I think, so I apologize. But with respect to Anderson, was the dismissal, had it been dismissed at the time the complaint here was filed? Wasn't Anderson dismissed after the complaint here was filed? It was before the petition for IFP status, but it was after the complaint. Is that right? Or do you know? I mean, I'm not trying to play gotcha with you, but, and if that's the case under the way the statute's written, wouldn't that be another basis to say this isn't an appropriate strike?
Burrell v. Anderson was affirmed, the circuit court affirmed the dismissal on 41B grounds in December 2022, and so you're asking.
Okay, do we look at when that's when it was affirmed on appeal?
Yes, that's correct.
It was dismissed by the district court after the complaint, and do we look at the date it was dismissed by the district court, or do we look at the date that dismissal was affirmed?
We look at the date it was dismissed.
Well, if it was dismissed, either way, right? They're both after the complaint was filed. And if they were dismissed after the complaint were filed, they couldn't be a strike that existed at the time of the filing, right?
Right, so Burrell.
I'm trying to give you another
Yes.
argument. I don't know
Yes.
if I'm.
He's helping you
Yes, absolutely.
a lot.
I'm just looking at my timeline to make sure I have the dates
And
right.
you could, in your time in rebuttal, you can
Yeah.
look at that because your
Yes, I
time
can
is
address that in
up.
rebuttal.
Thank you.
Thank you, Your Honors.
Thanks. All right, and we'll hear from the other side.
Good morning, Your Honors. Timur Rahman Duffy, as appointed amicus counsel, defending the district court decision below. May it please the court. The district court correctly determined that Mr. Burrell had 3 strikes under the Prison Litigation Reform Act. Only 2 are at issue here, the unknown dismissal and the Anderson dismissal. This court should confirm the strike calls for 2 reasons. First, both dismissals were for failure to state a claim. As Jones v. Bach explains, a complaint fails to state a claim if all the allegations taken as true do not show that the petitioner is entitled to relief. That's,
Isn't that too broad? I mean, what if it's a failure to exhaust?
well, the PLRA has specific exhaustion provisions.
Okay, so except for exhaustion would be an exception to the rule you just said.
I think that's right, just because the
And
PLRA.
jurisdiction, what about jurisdiction?
Well, jurisdiction, we would agree, isn't,
Okay,
because.
so that's another exception?
Yes.
Okay.
But we would think something akin to a statute of limitations ground or a immunity ground could be a failure to state a claim. That's also discussed.
How could an immunity ground be failure to state a claim? Didn't Congress sort of specifically leave that out of the list?
Well, in Jones, it explains that if those grounds are apparent on the face of the complaint, then it could be a 12b6 dismissal.
I just as a matter of statutory construction, I just want you to explain it to me, because Congress, in 1915A, specifically includes immunity as a grounds for dismissal, but then it doesn't include immunity in the directly adjacent list under 1915. I always assume that, like, Congress made a decision that we're not going to put immunity in the statute right next door because we don't think an immunity dismissal should be a strike, but you think it could be.
I think it could be, Your Honor.
How do you explain the failure to just carry over the exact same provision from the neighboring statute?
I think immunity could be a failure to state a claim if it shows up on the face of the complaint.
Do you have anything to say about the fact that in the neighboring provision, it lists frivolous, malicious, fails to state a claim, or immunity, and then right next door, it just does the first 3? Do you think Congress just forgot to put immunity in?
No, Your Honor. I think that immunity ground in 1915A could be broader. It could happen when it's not necessarily on the face of the complaint, where if the district
It would
court.
have to be on the face of complaint because the district court is dismissing it before docketing. What else is the district court looking at?
The district court could theoretically engage in a factual discovery.
By itself, sua sponte, with no defendant?
If necessary.
That'd be weird.
That would be
Okay.
weird, I agree. But going back, I would say even if the court holds that immunity grounds can't be strikes, statute of limitations grounds could certainly be strike calls. The Second Circuit has held they could be strike calls.
Even if that's true, abstention is refraining from acting on the complaint. I know here the words failure to state a claim were in the order, and I could appreciate, I think it'd be a tough call, but if you wanted to be real formalistic and say, hey, the words that are written in the order, we should follow them. But aside from that, it just seems like abstention is close to the opposite of dismissing for failure to state a claim. It's refraining to consider whether it should be dismissed for failure to state a claim.
I think that's the understanding that my friend on the other side has put forth, that the dismissal doesn't examine the underlying merits of the case, and therefore it's not a dismissal for failure to state a claim. But again, in a statute of limitations dismissal on the face of the complaint, that also doesn't examine the merits of the underlying complaint.
Well, it may, but it may not deal with the merits, and I don't know how statute of limitations would turn out, but it deals with a requirement that must be complied with to proceed with the statute. Maybe it's like exhaustion, maybe it's not, but those might be harder questions. But when you are literally refraining from exercising jurisdiction and literally refraining from the very question that the statute requires. I'm just seeing how that could possibly, comply with the statute.
Just to make sure I understand, when you say the question that the statute requires, you're
Failure to state a claim.
failure to state a claim.
Yes, sir.
Yes, Your Honor.
Yeah.
I would say that it's not refraining from what the statute requires. The statute requires that the court examine the four corners of the complaint and determine whether or not the petitioner is entitled to relief. In the unknown dismissal, the court did exactly that. The court examined the complaint. It recognized that in the complaint, it was asking the court to enjoin a pending state court proceeding, specifically asking for a change in venue. It walked through the exceptions to Younger and found that none applied, and therefore
But
dismissed.
isn't the whole question of abstention discretion? I mean, it didn't have to abstain, did it?
And under Younger, it did. If those,
That's mandatory if those are met? I couldn't remember that. but you may be right.
it's mandatory unless the state consents.
What about the fact that the district court itself issued an indicative order on June 4th, 2024, saying that it was wrong to count the Younger abstention as a strike?
I think this court is the court that's equipped to decide it at this point. So
you're saying the district court was right the first time and wrong the second
Yes,
time
Your
when
Honor.
it reversed its sua sponte reversed itself, or indicated that it would reverse itself?
yes, Your Honor. I think that the court had it right the first time, specifically because it dismissed the complaint outright because of Mr. Burrell's failure to establish grounds for which relief could be granted.
Counsel, you agree, right, that a jurisdictional dismissal is not a strike?
Yes, Your Honor.
All right, so just why do you think then that Congress would exclude jurisdictional dismissals? Those are not strikes. They don't reach the merits. You just filed in the wrong place. You filed too soon. But it does want to include Younger dismissals, which also don't reach the merits and also are just a matter of filing in the wrong court or too soon. Like, what would be the purpose of dividing those for Congress?
Your Honor, Congress explicitly stated when these courts have jurisdiction, that and constitutional grounds, Younger is different. Younger is this court deciding whether or not these courts should determine claims that have a subsequent state court proceeding.
But it's mandatory. You
It
were
is
just
mandatory,
explaining, like a jurisdictional dismissal.
They are like jurisdictional dismissals, but as this court held in Nevins,
No, I
they
get
are
it.
not jurisdictional.
They're not, but I'm just trying to figure out, and maybe the answer is, you know what, like, you think this is all clear from the text, so it doesn't matter, but I'm just trying to figure out if there's any, it's more comfortable if you feel like, well, maybe this distinction makes sense. Do you have any theory for why Congress would think, if you file in the wrong district court, that's not a strike, but if you file in the wrong court as between a state court and a district court, that's a strike. That's Younger abstention, and it's a strike.
I would push back a little bit on your categorization of Younger. It's not about whether or not you filed your claims in the state court or whether or not you filed them in the federal court. It's actually trying to enjoin a pending state court proceeding.
Right, and we say under Younger, if you can get a full and fair hearing of this claim in state court,
Yes, Your
take it up there.
Yes, Your Honor.
Okay, so in that sense, it is very much like you filed in the wrong court. This is a claim for you to take up in your state court proceeding.
I see what you're saying, Your Honor. Frankly, Your Honor, I think Congress understood that the failure to state a claim standard encompasses a great deal of dismissals. They have expanded what used to be simply the malicious and frivolity standard and state that failure to state a claim standard should also apply here. So it understood that it was encompassing everything that courts have dismissed under 12b6 or similar standards before, and that does include dismissals that do not necessarily reach the merits of the claim, such as extension doctrines and such as statute of limitations doctrines. If there's no more questions on Younger, I just want to briefly touch on the court's review of the actual complaint in the unknown dismissal. My friend on the other side said it had none of the hallmarks of the complaint. We would disagree with that take. The letter listed out Mr. Burrell's grievances. It listed out his proposed relief, which was a change in venue. It cited case law. It's hard to see how it's anything but a complaint. Also, for Ms. Burrell, the time to challenge this is too late, as this court has held in Blakely. IFP motions are not the time to determine whether or not the district court did it right. It's just to determine whether or not it is a strike call. One other thing I want to touch on, just before we go to the Anderson dismissal, there was discussion of posture, whether or not this court should allow Mr. Burrell to continue with his case below, or if it should do something else. We think the proper decision would be to vacate if this court determines that one of them is not a strike call, so that the district court could obviously use its discretionary power, but also to determine if other dismissals Mr. Burrell has, which we've listed out in our brief, count as strike calls. So that's that. Lastly, talking about the Anderson dismissal, we think that this is just a clear application of Blakely. Blakely held that the procedural mechanism for a dismissal here, which was 41B, is not determinative of the strike call. It's the substance over form, specifically whether or not the dismissal rang the PLRA bells. First, the face of the dismissal does explicitly state that the operative complaint failed to state a claim. It talks about how Mr. Burrell failed to hit the objective prong for his medical claims. It dismisses under 1915 AB1. So this language certainly hits the bells, and then as this panel discussed previously, the underlying orders discussing why Mr. Burrell's complaint was deficient, this court can take notice of as well. If there are no more questions.
What about the issue I raised with your colleague about does Anderson qualify, even if I were putting aside the argument you just made, should Anderson count if it was dismissed after this case was filed?
We think so, Your Honor, because that is a dismissal under strike grounds.
But doesn't the statute talk about 3 strikes at the time the complaint was filed?
That is one interpretation of the statute. I do apologize that we haven't briefed this.
Yeah, and I'm not no worries at all, but when you say that's one interpretation of the statute, that's not really an interpretation, that's just what it says if you read it, right?
Your Honor, truthfully, we have not considered this argument because Mr. Burrell did not raise it, so we are not as prepared as we should be to discuss it.
The question, we also have to consider whether Mr. Burrell can proceed IFP in front of us, right? Don't we have, I feel like the posture of this case is a little unusual.
I was a little confused about that, Your Honor. When I reviewed the docket, I didn't see that this court was determining whether it could proceed in an IFP motion for this court.
Okay.
And my assignment was to determine whether the district court had it.
Great.
So I don't think that this court has a discretion or is actually determining its own strike calls for the appeal.
Okay, that's great, thank you.
I hate to leave time on the clock, but if there are no more questions, I'll certainly give it back to the court.
That's fine. Thank you. We appreciate your argument.
We ask this court to affirm the strike calls. Thank you.
All right. You have 4 minutes in rebuttal.
Thank you, Your Honor. On rebuttal, I would like to address a few points raised by your questions. First, the process for determining whether an action should be dismissed for failure to state a claim is whether all of the elements of a cause of action are met to bring forth a claim that the plaintiff can seek relief. That is not the process the court in Younger v. Harris outlined. In Younger v. Harris dismissals.
If that's the definition, so where do you come out on statutes of limitations and whether a dismissal because you're outside the limitations period is a covered strike? Because that one also, you're not considering the elements of the claim.
When younger dismissal is an issue, the district court is never getting to the merits of the case.
Right, I'm sorry,
and
I was just
so-
wondering if you had a position on statute of limitations dismissals. If that's your standard, it's only if you reach the merits. Does it follow then that a dismissal for being outside the limitations period is also not a strike?
That's correct, Your Honor.
Okay, do you have any, okay.
So a dismissal on younger abstention grounds looks at principles of comity and equity. And as this court stated in Nivens, the district court is mandated to abstain when younger abstention issues come before the court. If Your Honors have no further questions.
Well, do you have anything to say about the timing of the Anderson?
Yes.
complaint?
We did look at the timeline. The Burrell v. Anderson was dismissed before Burrell v. Shirley, Your Honor. It was dismissed on May 2022, and Burrell v. Shirley was filed on June 2022. And so it was a strike before Burrell v. Shirley was filed. I believe amicus added Burrell v. Mayer to their brief, and that case is not relevant to the issue here today because Burrell v. Mayer was filed after Burrell v. Shirley was filed.
All right, do you have any other questions? All right, thank you very much for your argument.
Thank you, Your Honors.
And we'll come down and greet counsel, but I note that this is one of the rare cases where all sides are represented by court-appointed counsel, and so we doubly appreciate your efforts today. All right, come down and greet counsel. All right, we're ready to hear argument in our third case of the day, Rise for Animals versus Washington.
Thank you. Good morning, Your Honors, and may it please the court. My name is James Roselius, and I represent Plaintiffs and Appellants Rise for Animals and Animal Legal Defense Fund. Briefly, this case concerns a challenge to a USDA policy that was adopted in secret after the agency abandoned formal rulemaking. And the policy sharply limits what inspectors are allowed to inspect at certain animal research facilities. By adopting the policy, the USDA cuts off the very information in inspection reports, that is recorded violations, that Congress requires it to make public under the Animal Welfare Act. And as a result, RISE and the public cannot fully know whether these facilities are providing humane care and treatment to animals or what it is even that USDA is inspecting.
And where in particular in the statute is it that entitles Rise for Animals to the information that you seek?
Section 2146A, Your Honor, entitles plaintiffs to inspection reports.
Pardon, entitles plaintiffs to what?
Inspection reports, including all reports documenting all violations observed by USDA officials and all inventories. Congress did not leave it to USDA to define inspection reports. That is tied to 2146, which defines the scope of inspections. And Aikens really is the key here. This case falls squarely under Aikens, and the key in Aikens is that the court did not ask whether disclosure obligations were sufficient in the abstract. It first assumed for standing purposes that plaintiff's view of the law was correct, and then asked, do required disclosures flow from that view? So applying that logic here, if plaintiffs are correct under 2146 that more complete inspections are required, then they are entitled to the additional information in inspection reports that flow from that view under 2146A.
2146A is pretty, where is this, is pretty broad. Where's the specific language that you want to direct me to?
The language in 2146A, it requires APHIS, that is the Animal and Plant Health and Inspections Service, to make publicly available the following records. And under B1 requires all inspection reports, including all reports documenting all violations and non-compliances observed by USDA officials and inventories. So you can't know what an inspection report is without first knowing what an inspection is. And 2146 defines inspections, at least the scope of inspections, to be sufficiently broad to cover all deficiencies or deviations from the AWA standards. So looking at 2146.
I mean, counsel, if that's right, if that argument is right, that, you know, the statute, you know, talks about discerning all violations, and there was a policy that says, you know, we're kind of short-handed. You got to look at all three components, but in order to get everything done, we can only do it. You get 2 hours. Yeah. Anyway, there's obviously some constraints in the ability to determine every imaginable violation, be they time, be they manpower, be they just the errors in, you know, the process. And it seems like your argument would say anything that doesn't guarantee that if there is a violation, it's discovered, would also violate an informational right. And that just seems, I know that's not what you're arguing, but it seems like that's the extension of your argument to me.
Yeah, I don't think plaintiffs' claim is that broad as far as the language of 2146. I don't think it requires perfect inspections.
But you're saying that the reason you have an informational challenge is because the statutes that the inspection has to determine all inspections. And you've pointed out here, one way it might not do that is going to one of the 3 designated components of an inspection. But that argument, I don't see how it wouldn't. You may not want it to be that broad. I understand that, but it seems like the logic of that argument would mean that anything that didn't do that would be in the same way entitle you to standing.
Congress set a statutory floor, which I don't think is impossible for the USDA to meet. It simply is saying that the scope of inspections must be sufficiently broad to theoretically capture all types of non-compliances. It must encompass all the provisions of the AWA. That's a pragmatic approach. It's not a perfectionistic approach.
saying the language itself says that follow-up inspections must continue until all deficiencies or deviations are corrected. That doesn't imply perfection. It implies that the initial inspection must be sufficient in scope to allow the agency to identify all deficiencies or deviations. Otherwise, that would be unworkable. And that interpretation is bolstered by other provisions of the Animal Welfare Act. 2143 requires research facilities to show upon inspections that they are complying with the provisions of the Animal Welfare Act. And USDA's own guidance says that prior to the policy, its view was that focus inspections did not count towards the annual inspection requirement. So the shift to say they now do count towards what is required in 2146 is incompatible with the language of the statute and Congress's intent in amending this section to add a specific requirement for annual inspections that lead to correcting all deviations.
But aren't you, counsel, kind of, I mean, I hear you there, and you may or may not have a good argument that this, this method of inspection is incompatible with certain provisions of the act. But what we have to look at and what the district court found is whether that's true or not, you only get to bring a case if you have standing. And you pretty much, I know you have organizational, but I mean, I think it's pretty much informational standing when you read your complaint. And that means you have to have a statutory entitlement to the information. And you're not arguing, are you, there's any inspection reports that were issued that you didn't have access to, right?
That's correct, Your Honor.
So you're just saying they weren't good enough. You're not saying you didn't get them.
Well, we have to know what an inspection report is. Any document that is titled inspection report doesn't necessarily comply with the disclosure obligations. If it's a blank document with a blank inventory, that would not comply with what Congress intended. And
So what is it you want the agency to do for you, for
what
your
the agency
organization?
must do, according to the statute, is to conduct complete inspections in scope that would be sufficient to identify all sorts of non-compliances. What they're actually doing is looking at 1/3 of non-compliances by looking at only 1 out of 3 potential types of non-compliance in their annual inspection. And that doesn't meet the statutory floor that Congress set up in 2146. So in 2146A, it requires the results of the inspections to be disclosed to the public. And USDA says there could be no informational injury because they're giving us, as Your Honor said, the information that we're entitled to. They're giving us things that are called inspection reports. But that's the wrong frame under Akins, because under Akins, the court must first assume plaintiff's view of the law is correct and then ask whether they're meeting the disclosure requirements.
What's your view of the harm and adverse effect? How do you show that in this situation?
Your Honor, under this court's view, it would allow for being deprived of information under the statute is itself a concrete harm. The statute entitles plaintiffs to information, and being deprived of that information is a harm according to what Congress has set out.
So that's your argument, that because you didn't get the information, is there anything else?
Well, yes, Your Honor. Plaintiffs do not have to show additional harm, but they are animal protection organizations who use and rely on the information in inspection reports, and they allege that they are denied information that helps their advocacy to oversee USDA enforcement, to monitor these facilities' compliance, to let the public know what is going on through their databases they collect. And they are unable to do that because of what USDA is doing in severely limiting the information that is available to the public through these inspection reports under its policy.
Yeah, it just seems like with the Alliance for Hippocratic Medicine that the Supreme Court's telling us there needs to be some real impairment, almost in the sense of like that they analogized receiving a defective product. And I appreciate your first argument, the information's enough, I understand that, but if we think the recent Supreme Court decisions are requiring more than that. I'm trying to see how you fit into that.
Yeah, I don't read FDA, the FDA decision as limiting informational standing. It was touching on a specific kind of organizational standing that plaintiffs do not put forward
So
on.
you don't think that's relevant to our consideration?
No, I think it favorably cited Akins, and Akins is the standard under this court's decision in Laufer. But regardless, appellants have no problem meeting the harm requirement based on what they have alleged in the complaint and in their declarations they put forward. I also just point out in 2446A, USDA is not providing even what this provision requires on its face. They are not giving us documents, reports documenting all violations observed by USDA officials. If they're only looking at 1/3 of potential noncompliances, say they're looking at animals and they observe in the facility there's feces in the corner, they would not be reporting that in the inspection report because it does not fall within the narrow focus area of the inspection. And likewise with inventories, they're not providing us with inventories every year because they're not looking at animals every year. So either way you cut it, the policy is falling far short of what the disclosure requirement in 2146A requires them to do. So because the policy directly limits the creation of information that appellants are entitled to, and setting aside the policy would restore that flow of information, that is enough to find informational injury under Akins, as well as redressability and causation. I'd like to turn to final agency action with my remaining time. There's no dispute on the first prong of the Bennett v. Spear test. On the second prong, there are actually several legal consequences that flow from the action in question. And these affect both the agency and the facilities that it regulates. The policy binds inspectors to a mandatory policy. It mandates that they change focus areas every year. And it even alters the inspector's view of the law. Prior to the policy, they could take the position that focus inspections did not count towards the annual inspection requirement. Now their discretion is withdrawn, and they must take the view that it does count towards that requirement.
Well, it affects how they check for compliance with the statute, but it doesn't change any of the statutory requirements, correct?
That is correct, and that's not what is required under Bennett's second prong. What's required is that it changes the legal regime, and one of the ways that it can do that is by changing the expectations of enforcement for the regulated entities or their compliance behavior. The guidance even goes so far as to say they have worked hard to become accredited. They have a right to expect that inspectors will follow this guidance. So it is shaping their enforcement expectations and is limiting their potential liability. They are now responsible for only 1/3 of potential noncompliances. And that gives them a kind of safe harbor with respect to the other 2/3 of noncompliances under the Animal Welfare Act. And under the pragmatic approach espoused by the Supreme Court in Hawks, those are legal consequences that meet Bennett v. Spear's second prong. And the fact that they went through formal rulemaking on a substantially similar policy shows that they are thinking about this in terms of its legal effect. Finally, this is not a challenge to a failure to act on the agency's part. It is not a broad programmatic challenge. We are challenging a specific, discrete directive to agency staff.
Counsel, can I ask you to clarify when Judge Thacker asked you, what do you want the agency to do? You said, well, we want them to get out there and do full inspections. That makes it sound like you are trying to get into the day-to-day work of the agency. So even more specifically, what do you want the district court to do?
Yeah, let me be more specific. We want the district court to set aside the unlawful policy. Not asking for anything more than that. We're not asking for anything that requires any more judicial oversight than simply setting aside an unlawful policy. Thank you, Judge. And because of that, we fit within the second prong of Bennett v. Spear and can show final agency action. And so I'll just say that this policy erects barriers precisely where Congress intended there to be transparency and oversight. And beyond the general informational harm, it affects appellants by limiting the information they need to do their advocacy work by removing information about whether animals are provided humane care and treatment under the Animal Welfare Act. And that changes the legal regime for the agency and for the facilities that it regulates and for the animals that the statute is meant to protect. So for those reasons, we respectfully ask the court to reverse the district court and to remand on the merits of plaintiff's claims. Thank you.
All right, thank you. Mr. Springer?
Thank you, Your Honors, and may it please the court. Brian Springer on behalf of the federal government. I'd just like to take a step back and talk about the nature of plaintiff's claim here. At its core, plaintiff's lawsuit is an attempt to enforce a statutory provision that has nothing to say about the disclosure of information. Plaintiffs claim that the agency is required to conduct more comprehensive inspections of research facilities regulated under the Animal Welfare Act. Plaintiffs are not research facilities that house or handle animals, and they aren't subject to those inspections. But plaintiffs claim that they're allowed to challenge the adequacy of the agency's inspections because Congress has included a separate statutory responsibility for the agency to release to the public the inspection reports that the agency creates. I don't think that there's any case, I'm not aware of any case in which a plaintiff was able to leverage the fact that there's a disclosure provision to challenge a separate substantive obligation that they don't otherwise have the ability to challenge, and that's what plaintiffs are trying to do here.
Aikens is pretty close, right? Isn't Aikens more or less that fact pattern?
Your Honor, I don't think
tell me why not.
I don't think that that's right. I mean, Aikens was specifically about an extensive record-keeping and disclosure, set of requirements. And there, the dispute in the case was about whether an organization qualified as a political committee that then was subject to those disclosure requirements.
And also other rules, like being a political committee was going to subject them to a lot of requirements, not just disclosure. It's not all about disclosure.
Yeah, that's true, Your Honor, but it was the case that what the plaintiffs in there were seeking was a specific set of information, namely
like
information.
here. But that seems, I guess, let me ask you this. What if the agency here had, instead of doing the partial inspection policy, had just said, look, if you're a facility certified by a credible third party, you don't qualify as a research facility anymore, subject to 2146. So no need to inspect, no inspection reports. That would be Aikens, right?
Your Honor, I guess I still don't think that would be Aikens. I mean, here we're talking about two separate responsibilities that are set out in different subsections.
If it were one section, what if it were one run-on section, and it just says something like the secretary should inspect every facility at least once a year, look at the facilities, the animals, and the records, and then write a report and give it to the public? One run-on sentence.
Your Honor, I don't think that would make a difference. That would be the same thing as what happened in the DC Circuit case, Jewel. There, in one single sentence, there was both a deadline provision, or a deadline requirement, and then a disclosure requirement, and the court separated out the two and said, even if you're alleging that there was some non-compliance with the deadline requirement that would lead to the disclosure requirement being triggered, you still have to separate those out, and you have to be trying to enforce just the disclosure requirement. Here, plaintiffs, I think have admitted today that the agency is releasing the inspection reports that it's supposed to be releasing, so it's complying with its obligations under 2146A. But what they're trying to do is they're trying to use the fact that that has been tacked on to challenge the substance of the of the inspections themselves, the way that the agency actually runs its inspections, which is an entirely separate requirement, and here it's underscored by the fact that it's actually set out in a different subsection, namely 2146. And I know it's a little confusing. It's 2146 subsection A versus 2146A. Your Honors, I'm happy to address any other questions that Your Honors may have.
I do have a question. I'm just trying to make sure I kind of understand the outline of the arguments here. So you're making, even if, in my hypothetical, even if, you're not arguing that you can't read 2146 parentheses A to require what the plaintiffs are calling a full inspection, that each year you inspect the facilities, the animals, and the records. Even if it said that, just straight out, you would still be here saying, well, but that's a different provision.
That's correct,
Okay,
Your Honor.
that's right.
I mean, you know, obviously, the agency doesn't think that's the right way
Right.
to read
But that is not,
2146.
that's not like the premise of your argument.
That's correct, Your Honor. Even if you
can give
accept.
that up, okay.
Correct, Your Honor. Even if you accept everything that the plaintiffs are saying about the right way to read 2146 subsection A, it would still be the case that they don't have informational standing.
It's extremely helpful, thank you.
Counsel, on the harm and adverse effect issue, I'd asked your colleague about that, and he pointed to the Lawford case. How do we, what's your way? We have Dreher, we have Lawford, then we have the recent Alliance case. What's your understanding of what has to be shown in the way of harm? Is just the absence of information enough? Because I do think Lawford, that's a fair reading of that case. Now, it's a unique case, maybe as a tester case, so maybe we got a rule for testers, but we got to deal with that. And so how do we look at those three cases and tell us what we're supposed to do there?
So, Your Honor, we haven't taken a specific position on this question in this case because the district court didn't reach it. The district
Well,
court
I'm asking
said,
you to take a position as best you can, because I might want to reach it.
So, Your Honor, the D.C. Circuit has said that there's sort of two separate requirements. It has
Right.
said that there's a requirement that you show that Congress has said, you know, by statute, that the agency has to produce the particular information at issue. And that's really what the district court went off on here.
Right.
But the D.C. Circuit has also said, reading Supreme Court cases, that there's a separate requirement that you show that there's some harm that flows from
Doesn't
that.
Dreher suggest that too?
And that's correct, Your Honor. This court's decision in Dreher suggests that as well. There does seem to be sort of a little bit of, you know, potentially tension in this court's cases on that front as to exactly what showing that needs
Right.
to be. I do think the Supreme Court's cases, particularly the more recent Alliance for Hippocratic Medicine, suggests that there has to be something more, you know, there has to be an actual harm that flows. And here, all plaintiffs are pointing to is just the alleged denial of information.
A second ago, when I asked, they said, no, we're an organization, and this impairs our ability to do what we do. I mean,
Sure.
Is that, if there is some harm, is that enough?
Your Honor, just the kind of abstract impairment of the mission is exactly what Alliance for Hippocratic Medicine said doesn't count. They said you can't just divert resources and say that, you know, that sort of internal moving around of
I
money
think they're
counts.
saying I think they're saying more than just resources. Maybe I misunderstood them, but it sounded like they're saying from an effectiveness standpoint, we can't do what we do. Which, you know, may be a Havens Realty type claim, maybe not. But I think they said more than just it's, you know, affecting our resources.
Your Honor, I think here the allegations really were about the diversion of resources. I mean, even if you took them to be saying something broader, again, Alliance for Hippocratic Medicine specifically addresses this idea and says sort of, you know, a harm to your abstract mission and sort of the way in general you're kind of approaching something is not enough. I mean, it specifically talked about havens
Right.
and limited havens to a situation where there was a very concrete effect on the way that organization was doing business. It wasn't just sort of an abstract, you know, this
Seems
is
pretty
hurting
much
our
like
mission.
Havens is as far as this can possibly go, unless you're on par with Havens, you're going to have a hard time on this issue. Do you agree with that?
I agree with that, Your Honor, and I think here the plaintiffs themselves have abandoned the theory of organizational standing that they now seem to be, you know, to some extent talking about today. That's exactly.
But that harm is an element of informational standing, right? To the extent we find it in Dreher in an informational context, right?
Your Honor, I think Dreher suggested that there is that extra
Right.
harm requirement, and that also flows from D.C. Circuit cases as well as the Supreme Court cases.
But how are they not harmed? I mean, again, I don't understand them to be making, or I don't understand the plaintiffs to be making a diversion of resources argument. I mean, this is their thing. They're animal rights groups. It used to be that every year the inspectors had to come in and inspect the animals, not just the facilities, or not either or, facilities, records, or animals. So theoretically now, it's by hypothesis, they're only looking at the animals once every 3 years. This is their whole thing. It's what they do. They want these reports about the condition of the animals, and now they're not getting them. It's not like there's some competing facility that has an economic, wants to make sure the inspections get done against a competitor. I mean, they have a real need for this data about the animals, and that was exactly why Congress passed the statute, so that the animals would be inspected and the public could kind of keep everybody on their toes. This one seems, I don't really see the difficulty in identifying a harm in this case. And not only is there a harm, but it's the harm the statute was aimed at.
So, Your Honor, I guess I think the thing that's important here is we're talking about sort of two separate, again, to sort of return to the original point, we're talking about two separate statutory responsibilities. And the one that the plaintiffs, are sort of trying to use is the one about releasing information to the world, which the agency is doing. It's conducting inspections, it's releasing the information to the world, and plaintiffs, I don't take to dispute that that's what's happening.
I do understand your two-provision argument, yes, or two different duties argument.
Your Honor, and the reason I think that's important in response to your question is that, this whole statute is a scheme about protecting animals, providing humane care and treatment to animals at research facilities and when they're sold in an exhibition. That's what the whole kind of focus of the statute is. And then Congress tacked on this additional disclosure provision that says that when you do the inspection reports, you release them to the world. But that doesn't mean that sort of this whole thing turns into a disclosure provision. This is all about protecting the animals.
Right, but one of the ways Congress sought to protect the animals was by getting, having, I can't think of the phrase, but what do they say in the key TAM context? Like private attorneys generals almost. You're going to have public disclosure so that members of the public can sort of be engaged in this process, where if something is going wrong, there will be a public outcry.
We're not disputing the idea that it is true that Congress wanted these inspection reports to go out to the public, and so that provision is doing some work and is requiring the agency to release that information to the world. But usually, when you're talking about standing, there has to be some sort of concrete effect on what, to the plaintiff, that's ordinary standing principles. And I think that what plaintiffs are trying to do here is sort of an end run around that.
So it should be this is the animals would have standing, but not the people who protect the animals.
Your Honor, right, these plaintiffs are sort of a step away from, they're not the regulated entities, they're not the ones who are housing the animals and keeping the animals in their care. They're sort of one step away and saying, because they get information from the agency, they should be able to reach back.
Can't Congress have a provision that does, require the availability and production of reports so that there is sunshine, there is the ability to have public outcry, but that's not the same as standing to bring a lawsuit. Aren't those different things that we do want to bring maybe some exposure and people can take actions and do all sorts of things, but there's a difference in doing that and coming to federal court and say you have standing. Is that right or is that wrong?
Your Honor, I think that's correct, and that's why these informational cases in particular are sort of limited to enforcing the part that's about information and the part that's about releasing information to the world, not, those don't sort of create a mechanism and open up challenges to everything that the agency is doing, which is what I think the plaintiffs are trying to do here.
What's your position? I asked your colleague about the final action issue, and in particular whether rights had been altered, and I think he agreed that there wasn't a change in the requirements about what facilities and people who are dealing with these animals must do, but he pointed out that there is a change in the expectations of the inspectors. Is that a change in legal rights and responsibilities under the law as you understand it? What's your response to that?
Your Honor, I don't think that it is. I don't think that that's enough. You know, usually what's happening in the cases that I think the other side is referring to, and particularly, for example, the Hawks decision, that was one where a position that the agency took actually affected the legal rights or obligations of the regulated parties themselves. So there it was a jurisdictional decision about what waters kind of came within regulation, and it would provide a potential safe harbor to the landowners themselves for a period of at least 5 years. So there was an actual determination of the legal rights and obligations of the regulated parties.
If those waters weren't U.S. waters, they weren't subject to the regulations at all.
That's correct, Your Honor. Whereas here, what we're talking about is we're talking about the way the agency checks for compliance to make sure that everybody's complying, but that doesn't actually change the underlying substantive standards that all of the regulated facilities must continue to comply with.
So they might say, well, if you're only inspecting one of 3 categories, from a practical standpoint, the adherence to there's a less likely, there's a greater likelihood that there won't be compliance. If you're only checking one of 3, maybe you don't run quite as tight of a ship. Or maybe, I know it's not like you go 1, 2, 3, so you know there's not a prior knowledge of what the one's going to be the next year, but maybe practically they don't do as good of a job. Is that the way we look at this, or do we look at what the ultimate legal requirements are?
Sure, I have 2 responses to that. I mean, one that's sort of legal and one that's sort of practical. So on the legal front, I think the way the cases talk about this is they're talking about legal rights and obligations. They're not talking about sort of, as a practical matter, how this shakes out in practice. And so I think here, again, the Hawks decision is a good example of something that was an actual kind of potential, legal liability shield, not just a decision that was being made internally that may kind of in the real world play out in one way or another. But I guess I also just want to make sure that it's clear that in this case, the agency has devised a policy that it thinks is doing enough, based on its limited resources to check for compliance. I mean, we're talking not about all of the facilities. We're talking about research facilities, and we're talking about a specific subset that the agency thinks are low risk. And in those circumstances, on occasion, it's only checking certain parts, but then other years it's doing a complete inspection, and that should be enough to actually make sure that, everybody is complying with their substantive obligations that aren't changed by how the agency is checking for compliance. So, Your Honors, if there are no further questions, we would ask that this court affirm.
All right, thank you.
Thank you.
And you have 2 minutes in rebuttal.
Thank you. I would just like to respond to the argument that appellants are bootstrapping the standing by finding 2 unrelated provisions and tying them together. When Congress adopted 2146A, it was aware of 2146 and intended them to be related. Under the government's position, they could institute a policy that instructs inspectors to close their eyes upon entering a facility. And that would be fine under the disclosure requirement because these are 2 distinct sections. I don't think that's what Congress intended when it adopted 2146A. This is just like Aikens, where there is a legal determination that directly impacts the disclosure that is required by a disclosure provision. With respect to Judge Quattlebaum's, your question about how Dreher and Spokio, or Dreher and Laufer interact with one another, I think Dreher and these Supreme Court cases, Spokio and TransUnion, they dealt with bare procedural harms, where the harm was not the one intended by Congress in enacting the disclosure statute. And so some additional harm was required. Here, Congress adopted a disclosure mandate that essentially deputizes the public to oversee the USDA's enforcement regime. So depriving the public of information that they're entitled to is itself a harm under the Laufer and Aiken standard. Just quickly, the harm that appellants face here is not a Haven-style injury. It is that we do not have information about whether facilities are in compliance with the AWA. Specifically, the language referring to inventories and observed violations. USDA's policy makes it so that we do not have those inventories, we do not have those violations in our hands. Thank you.
All right, thank you. We'll come down and greet counsel and proceed to our last case. All right, counsel in the Hollis versus Morgan State. Okay, wait just a second. She needs to. We'll let her get settled first, okay? All right, whenever you're ready, go ahead.
Your Honors, may it please the Court. Regina Wang on behalf of the appellant, Dr. Leah Hollis. Ever since Morgan State University set Dr. Hollis's starting salary at the lowest pay on the departmental pay scale, it has allowed the pay disparity with male comparators to grow. MSU has offered at least 4 justifications that a jury could determine are pretextual. First, with respect to the initial pay disparity, MSU has offered justifications in litigation that it did not offer at the time of hiring. Second, MSU claims that her 2016 promotion application was untimely because her initial 3-year term had not been renewed. But for the prior 16 months, over a dozen administrator and faculty at MSU had considered Dr. Hollis's application, and no one had suggested that it was untimely. Third, MSU criticizes Dr. Hollis's scholarship for being published in venues in which she was affiliated, but it praised Dr. Gawley for being affiliated with venues in which his work appeared. And finally, with respect to her promotion applications to full professor, MSU discounted her works in progress and reviews and work scholarship that she achieved prior to achieving tenure, even though it considered these qualifications both for Dr. Robinson and Dr. Gawley when it considered their promotions to full professor. Today, I will start with Dr. Hollis's wage discrimination claim, then move on to sex discrimination, and finally turn to retaliation.
Is in your introduction there, does that cover, it seems like, just hearing it, it's focused on the employment, the paid claim generally, and the employment decisions before the 19 and 20 decisions. Am I understanding? And I'm not suggesting you're waiving that, but it seems like your introduction is focused on the earlier promotional decisions.
No, so I actually,
you didn't mention anything about like timeliness and exhaustion, but
yeah,
maybe you're going to get to that.
Yeah, I'm going to get to that. I'm just mentioning the procedural things, but I did mention, the 4th thing I mentioned was on the merits of her promotion applications in 2019 and 20 to full professor. Okay. MSU discounted her works in progress and also her prior work. So starting with her wage discrimination claim, under the Equal Pay Act, Dr. Hollis has established a prima facie case by showing that she was paid less than male comparators. The burden then shifted to MSU to show that a factor other than sex in fact explained the pay disparity.
Why do we care if she has made a prima facie case or not at summary judgment? Why aren't we just looking to whether there's a genuine dispute of material fact about whether she's been she's been discriminated against on the basis of pay? I mean, at summary judgment, if there's a ruling, we got to review it. I understand that, but just why are we talking about a prima facie case at summary judgment?
Sorry, so yeah, I guess the prima facie case isn't really disputed. The dispute here is really, under the Equal Pay Act, the burden is on MSU to show that the factor other than sex explained the pay disparity, and so at summary judgment, MSU can only prevail if there is no dispute that MSU was in fact motivated by this factor other than sex. And here, Dr. Hollis has presented evidence from which a jury could determine that both the initial pay disparity was not in fact motivated by a factor other than sex, and also that MSU allowed that pay disparity to persist and in fact even to grow, notwithstanding Dr. Hollis's strong performance. So with respect to the initial pay disparity, MSU points to the qualifications of each candidate at the time of hiring. And for example, for Dr. Gawley, MSU claims that now, in litigation, that he had better community college experience. But this was not the justification they offered at the time of hiring. So a jury could question whether this really was the factor that drove MSU's decision when they set his salary at a higher salary than that of Dr. Hollis. Dr. Gawley had just finished his doctorate when he was hired at MSU as a lecturer, and then MSU immediately decided they would hire him as an assistant professor at a salary that was $5,000 higher than the starting salary for Dr. Hollis. Taking another comparator, for example, Dr. Davis, MSU considers the fact that he had community college administrative experience in leadership roles at a community college, but that was not a criteria that was listed in the job posting, so a jury could disbelieve that that was really a reason why his initial higher salary was justified.
Is that right, that if you don't list a factor in a job posting, you can't rely on it as a basis for a different salary in litigation? You hold people to that?
No, that's not necessarily true, but there is enough evidence here where a jury could disbelieve that MSU was really motivated for each of these male comparators by the factors that they're now offering.
But you're not saying you necessarily get to a jury every time you can point to a distinction between a justification offered in litigation and a job listing, or a resume for that matter, comes up in that context also.
Yes, that's correct. And to the extent we think, for example, that it would be hard for a jury to determine qualifications at the time of hiring, MSU further allowed the pay gap to grow during the time that Dr. Hollis was at MSU. For example, in her first 5 years, her salary increased by less than $7,000, even though she was promoted in that time. And Dr. Davis was not even promoted in that time. He remained an assistant professor, yet his salary increased by over $10,000. So even if the initial pay disparity is maybe something hard for a jury to determine, at the very least, MSU impermissibly allowed the pay cap to grow, or at least a jury could so determine. If there are no further questions about the Equal Pay Act claim, I will move to the sex discrimination claims. So I'll start with the decision to deny her promotion application in 2016. MSU has offered 2 justifications for why her promotion application was denied, and that alone could lead a jury to determine that these justifications are both pretextual. One justification that initially offered was that her qualifications were insufficient, and then later, 16 months later specifically, for the first time ever, MSU suggested that, in fact, she had not been renewed for a second 3-year term, and this was partway through her second 3-year term that they made this discovery, and then claimed because of that, her promotion application was untimely, and therefore it would not even consider the merits of her appeal.
Counsel, am I right that on the 2016 promotional claim, the district court found that there had not been a prima facie case established?
Yeah, so that was, the parties both disputed the prima facie case and pretext. So the disputed factor on the prima facie case was whether she had presented evidence to raise an inference of discrimination.
This kind of goes back to what I asked you on the other claim, is who cares? I mean, prima facie case is a lower standard than summary judgment. We're at summary judgment. Our question, shouldn't it be whether there's a genuine dispute of material fact about discrimination in promotion on the basis of sex? And it seems like, you know, there's a debate about the prima facie case. We're probably partly responsible for that. But at summary judgment, should we, or is that even relevant?
I guess the case law isn't super clear on which stage you should consider all this evidence, but the same evidence goes both to her prima facie case and to whether their justification is
The same arguments you would make, you're making about that, you would make about whether we were just dealing with the basic summary judgment standard, right?
Yes. And so here,
Is there another issue? As I read the district court's order, it looked first at direct evidence.
yeah,
And said it didn't find there was a genuine disputed material fact. That was mainly the Laboon affidavit.
yeah,
And then it said no disputed general fact. Then it turned and said, I'm gonna do McDonnell Douglas on circumstantial evidence.
yeah,
And looked at that.
yeah.
As if those were two forms of evidence that you couldn't consider together.
Yeah.
I mean, at summary judgment, can't you consider direct and circumstantial and see whether combined all the evidence creates a genuine disputed material fact?
Yes, that's precisely right, and we think all that evidence together is sufficient to survive summary judgment. For example, the Laboon affidavit may not be sufficient to be direct evidence, but it certainly is evidence that can be considered as indirect evidence, together with the other evidence from which a jury could determine that MSU's justifications were a pretext for sex discrimination.
Why wouldn't the affidavit of her supervisor saying I'm never going to promote her be direct evidence of discrimination?
So she was not the final decision maker here, but
I
she
know,
was
but she was her immediate.
Yes, and she was someone in a position to influence the outcome. And so that is,
Are you backing off that that's direct evidence of direct?
we're using it as indirect evidence only because there's so much other evidence as well that we think this court should consider holistically rather than just considering that one piece of evidence. So here, there's the fact that male comparators were promoted when Dr. Hollis was not. There's also the fact that MSU has offered different justifications at different times, and also the fact that there were procedural irregularities in the treatment of her promotion application, both at the initial stage and also on appeal. And all of this could together lead a jury to determine that MSU's justifications are all just pretextual, and this was actually all motivated by sex discrimination. So something that I mentioned in my opening that is relevant to both her 2016 promotion application and her 2019 and 2020 promotion applications is that while universities are certainly free to choose the criteria on which they judge various candidates, they must apply those criteria consistently. And here, there's evidence that MSU has offered justifications that it did not apply consistently across male and female candidates. For example, Dr. Hollis was strongly criticized for her research and specifically for the fact that she had self-published works and also that she had works that were published in venues with which she was affiliated. But for example, Dr. Robinson also had self-published works, and Dr. Ghali also was affiliated with various journals in which he published his work, and yet both of them were granted promotion every time they applied for promotion. In fact, if you look at the JA starting from, I think, page JA 1865 onward, where it shows the promotions from 2016 to 2021, MSU has never denied a male applicant in the department's application for promotion. It has only ever denied or deferred applications by female applicants. And this is something a jury could consider in determining whether, when it denied and deferred Dr. Hollis's promotion applications, this was actually motivated by sex discrimination rather than by the shifting justifications it now offers. And then also turning to her applications in 2019 and 2020, something else that I mentioned in my opening is that Dr. Hollis was criticized, or her works that were in progress or that were achieved prior to achieving tenure, MSU seemed to discount when it was deciding whether she should be promoted to full professor. But when, for example, Dr. Robinson applied to full professor, he barely had any publications since he was granted tenure or teaching reviews, and MSU just considered all of his qualifications that he had achieved prior to achieving tenure in determining whether he should be granted promotion to full professor.
Counsel, the district court didn't reach the 2019 and 2020 sex discrimination claims on the merits, right?
Yes.
Those were. Can I ask you a question about that? So the district court applied Title VII procedural bars to those two
Yes.
claims, but your client was also suing under Title IX and Maryland law in 1983. same-sex discrimination claim in 19 and 20. What happened to those claims? Because those don't have the procedural bars.
Yes, so this court, even if it determines that one of those procedural bars applies, that doesn't apply to any of those claims.
Right, so what is your understanding of what the district court did with those claims?
The district court considered them on the merits. Oh, so you mean the related claims?
Yeah.
I guess the district court just decided they were all gonna get thrown out because there was this procedural bar on the Title VII claims.
So you think the district court believed that if you want to file a 1983 claim, you have to wait 90 days after you get your right to sue letter from, I mean, the district court thought that these procedural bars applied to a 1983 claim and a,
Yeah, well, so yes, the district court seemed to apply it across all the claims that were related to those same sex discrimination claims, but for example, like the timeliness defense, MSU has only raised that with respect to her application for promotion in 2019, so that defense does not affect her wage discrimination claims or her promotion.
right, I'm just trying to figure out, one of two things happened here. Either the district court made a colossal error and believed that if you're filing suit under section 1983, you have to get a right to sue letter from someone and then file within 90 days, or the district court just kind of spaced on 3 of the claims in this case. Do you have a sense of which of those two things happened here?
It seems to have been the latter, just there were so many claims brought that they probably just lumped them all together. But on those procedural defenses, as I mentioned, they only really focus on specific claims. So for her promotion application in 2019, they've raised a defense that that claim was not timely. And with respect to 2020, they've argued that that claim was not exhausted, and we've explained in our briefs why both of those things are not true. Her 2019 claim was timely because it relates back to her original complaint, and her 2020 claim was exhausted because it was reasonably related to the 2 EEOC charges that she brought.
Can I ask you a quick question about that? Assume for a minute the district court was right and the 2019 claim was not timely.
Yes.
So the 2019 EEOC charge kind of washes out.
Yes.
If you're trying to relate back.
So that doesn't say the 2019 EEOC charge.
Wait, she wasn't finished with her
sorry,
question.
Sorry.
So if you're trying to argue that the 2020 claim is reasonably related to the 2019 claim, I think it has to be, you think you can make that argument even if the 2019 claim was not timely. It would still be sufficient to show that, to save the 2020 claim, that one was reasonably related to the 2019 charge.
Yes, so there's the 2019 claim and there's a 2019 charge.
I understand, yeah.
And so the reasonably related is just to the 2019 charge, and whether the 2019 claim is timely or not doesn't affect the underlying 2019
I think it has to be related
charge.
to an EEOC charge that was the proper basis for subsequent litigation, is the way we framed it, and I can't remember the name of the decision, but the decision you cite. We say, no, it's okay as long as it is related to a EEOC charge that was the proper basis for subsequent litigation. So I have a slight concern here that actually your 2 claims are tied together, that they're gonna rise or fall together, which might be fine, because you think you're gonna win on both anyway.
Yeah, I mean, we think we do win on both, but no one has suggested that the 2019 EOC charge is no longer proper to consider just because she did not timely amend her 2019 claim. So even if you were to determine that the 2019 claim had not been reasonably amended, that doesn't mean the 2019 charge just disappears. And
All right, thank you. You have some time on rebuttal. We'll hear from Ms. Watkins now.
May it please the court, Courtney Watkins on behalf of the appellees, Morgan State University, and the individual administrators that were the defendants in the underlying case. Appellees are here today to ask this court to affirm the decision of the district court granting summary judgment to the appellees on all counts against the defendants, the appellees in this instance. Beginning with the sex discrimination claims, specifically the lower court had found that the 2019 to 2020 claims were untimely because they were brought 140 days after that right to sue notice.
Can I ask you the same question I asked your colleagues?
Yes,
So
absolutely.
what about the Title IX, the 1983, and the Maryland law claims?
Your Honor, candidly, it was an issue that was not raised at the lower level, and it doesn't seem like it was specifically addressed. I don't think that there's anything in the opinion to suggest that the decisions regarding the 2019 to 20 and 20 to 21 denials of promotion and tenure were based off of a merit argument, because the court summarily dismissed them based off the procedural grounds. I don't think it was an issue that was addressed. But to Your Honor's point earlier, if this court determines that that 2000...
So do you think those claims are still out there, or was summary judgment awarded on these other three?
Your Honor, I believe summary judgment was ordered on those claims as well, and I guess if
But there
summary
was just no
judgment...
analysis done for the summary judgment grant, is that what you're saying?
Yes, Your Honor.
I will tell you, just my concern, I don't want to hide the ball or anything, is we do have case law saying that even where the district court thinks it has addressed all the claims, if it didn't address some of them, then we don't have a final order.
Yes, Your Honor, I was thinking the same thing a moment ago, whereas if it's a situation where not all of the claims were addressed in the underlying decision, then technically it's a jurisdictional issue as to whether this is ripe for appeal at this moment.
But, yeah, that it is interesting order to try to discern what happened. There's a footnote that says you treat those related claims like Title VII. There's and to an extent that's true on the merits, but as has been pointed out, some of the procedural requirements don't apply. There's no discussion of that, but it seems to dismiss, it doesn't say claim, it's plural each time. So, maybe, what's your position? You said you were thinking that. I mean, do you have a position as to whether it is a final order or it's not a final order?
Your Honor, I do believe it is a final order. Ultimately, even though it wasn't specifically addressed, the claims were decided in their entirety, whether it was based off the meritorious reasons that were argued by both parties or, in this instance, the procedural grounds. I think ultimately there was a final order. Whether there was the factual basis or the legal basis for the other elements is not as clear, I would say.
Okay.
But addressing the other issue that was raised, if this court finds that that 2019-2020 claim was untimely, then by this court's precedent in Jones versus Calvert Group, the claim from the 2020 to 2021 promotion cannot then serve or relate back to the investigation that was done by the EEOC, because the retaliation claim has to relate back to a charge that's properly before the court in the first place. So because that 140 days had passed and the charge wasn't timely, and because that 2020 to 2021 decision was never actually exhausted in the EEOC with respect to that Title VII claim, the court properly dismissed the Title VII claims with respect to the 2019 and 2020 promotion. Now, in terms of focusing on that 2016 to 2017 promotion cycle, the affidavit that's been referenced substantially in this case, the affidavit of Steve Laboon, is a factual issue in that it was a occurrence that allegedly happened soon after Steve Laboon joined the university, when he was a new student before he attended classes where the dean purportedly made, or excuse me, the department chair had purportedly made these discriminatory marks in front of him. We're not saying that that is not a factual issue. It is. But there has been a period of 2 years between when those remarks were allegedly made and when the promotion decision was first made in 2016 with that 2016 to 2017 application.
So what's the big deal in 2 years? When she was hired, the affidavit says her supervisor says she's never going to get a promotion. First time promotion comes up, she doesn't get it.
Your Honor, I think that there is a difference between the facts of this case and the facts cited in the case by appellant, which is that Wanamaker Amos case.
Well, maybe different facts. I'm just saying, why couldn't a jury say, look, I have no idea if what was in that affidavit is true or not, but there's an affidavit that the supervisor of Ms. Hollis said, you're never gonna get a promotion here. I'm restricting pay for discriminatory reasons. And, I mean, again, juries may say that, I'm not gonna consider that for, a bunch of credibility-related reasons, but, I mean, how does that not create a question of fact on at least everything up besides retaliation here?
Well, Your Honor, because in every single level of review, Dr. Prime, who's the person that purportedly made these statements, was neither the first nor the last person to call into question the credentials of the applicant, Dr. Hollis.
So if there's other people who say something, the supervisor's discriminatory mark should just be not cast aside, jury doesn't get to consider them?
Your Honor, when there's the period of 2 years that passed between when those remarks were allegedly made and when the decisions were made, when Dr. Prime was not even the initial person to recommend against promotion, she was highly criticized, Dr. Hollis, by Dr. Whitney Johnson, and there's been absolutely no evidence of any discriminatory animus on Ms. Johnson's part. And ultimately, the school committee that reviewed her application in 2016, 2017, after that, all uniformly made the determination that Dr. Hollis was not qualified for promotion and tenure at that point.
Why isn't that a just fabulous jury argument?
Well, Your Honor, I also think the fact that there were intervening acts in between when the remarks were purportedly made in 2014, and when the decision to deny promotion happened in 2017, like Dr. Prime, giving Dr. Hollis a positive review from her first year, saying that she showed progress in all of the categories. And even in March of 2016, Dr. Prime and Dr. Hollis had a conversation where Dr. Prime had indicated that that Dr. Hollis could apply for promotion and tenure at that point because of the number of publications that Dr. Hollis had at that time. Prime's issue that she eventually discovered when she reviewed the application wasn't that Dr. Hollis's number of publications was too low, it was that the quality of the actual publications was not sufficient to earn that coveted role of tenure and promotion in this institution.
So, putting aside the promotions, what about the unequal pay claim? I mean, she set the pay, right? And she set the pay around the time she allegedly made those discriminatory marks, right?
She set the pay prior to allegedly making those discriminatory marks,
Pretty close
within a similar time frame.
The remarks were around the time she started working, right?
The remarks were August and September of 2014, allegedly. She had recommended her salary in February of 2014. So it was 6 months prior to the statements allegedly made.
So you're thinking that 6 months is enough that we don't consider it at all in the pay claim?
Well, Your Honor, I think with respect to the pay claim, when you're looking at the qualifications of the different folks that were offered up for the pay that they received, it's not a situation where the qualifications are similar. These people had significantly more community college experience.
But they're making more, materially more, all of them. And you have a statement from the person who sets her pay that is discriminatory about how she's going to be paid. I mean, if I was a plaintiff, I don't know if that's, how is that not a question of fact?
Well, Your Honor, I think that in this case, there was the issue about the separation in time between when that statement was made and when it was subsequently, when the pay determination was made and then when she was subsequently, when Dr. Prime subsequently allegedly made that statement. I think the other issue is that in this specific case,
I just don't see why the pay, I'll be quiet, I know I'm taking up time, but it seems like the timing, when the statement is a kind of categorical statement that I'm going to act in a way that's discriminatory about your workplace. And, you know, a jury could say that's how I'm going to treat you while you work here. The fact that it might not be right at the time the pay decision was made just seems, you know, maybe a factor, but certainly not a conclusive factor.
I think the statement is also significantly undercut by the fact that Dr. Prime recommended significantly higher salaries for other female professors that started.
We usually don't talk about undercutting and stuff like that at summary judgment.
Well, Your Honor, I think in this case, when it's a statement that happened 6 months prior, the decision ultimately was made to set her salary at the $60,000 amount. And under the EPA, the 4 categories include that factor other than sex. When we're looking at the actual qualifications of the candidate, they were far and above what Dr. Hollis was presenting at the time that she applied for promotion and tenure. At that time, she was a non-tenured administrative or faculty member at for-profit universities. She didn't have community college outside of the 1 year at the Community College of Philadelphia, and that specific experience was not the level of involvement with the students that the other professors had demonstrated. For example, Dr. Russell Davis had served as the president of a community college for 3 years. He had served as a vice president for 4 years before that. He had significant experience in other community college-related positions. And although appellant in this instance has tried to diminish that experience by saying that he had earned that experience through falsified credentials, there's absolutely nothing in the record to suggest that any of that information was available or considered by the university at the time that they made the salary determination. The other comparators that are used in this instance include Dr. Ghali, who was at that point had the primary assignment with the community college leadership program, and he had also had a contractual position in the Department of Advanced Studies as a lecturer and was joining since contributing to that department. So he had experience within the department already at that point, and then the subsequent situations where the pay disparity increase was purely a matter of the COLA increases or the merit-based increases that were, by and large, went out to the entire department, or in some instances where a person had earned tenure and promotion or promotion to full professor in the case of Chris Robinson, or later Dr. Ghali. In those instances, the determination was made by several levels of the school that Dr. Hollis did not possess the qualifications to be promoted to full professor. She was promoted in 2018 to 2019 to the associate professor position, and she was granted tenure. But following that promotion, she didn't demonstrate the level of research or teaching or general philosophy required in order to receive that designation of full professor. And in those specific instances, those 2019 and 2020 promotion cycles in 2020 and 2021, Dr. Hollis was not the first, second, third, fourth, fifth, sixth, seventh, eighth person to review the candidate in that case. Instead, the entire departmental committee in both instances recommended against promotion in that 2019 and 2020 to 21 cycle. And the school committee, by a majority, had also recommended against granting promotion in those instances. Dr. Prime had transitioned to be the dean of the school at that point, so it wasn't until all of the lower decision makers had already made the determination that Dr. Hollis was not qualified at that stage to receive promotion and tenure. It's only at that point that Dean Prime had agreed with the prior assessments. Even looking back at that 2016 to 2017 time period where Dr. Prime was second in line after the 3 departmental committee members that reviewed the application first, ultimately, Dr. Prime actually gave a more favorable evaluation of Dr. Hollis than Dr. Whitney Johnson did at that first level. Dr. Whitney Johnson had rated her lower in service, whereas Dr. Prime had given Dr. Hollis a rating of excellent in service. They both had found that her research was unsatisfactory because in this case, Dr. Hollis had focused on the quantity of the research as opposed to the quality. Even included in her dossier that she submitted for that 2016 to 2017 application was that letter from the editor that said that you needed to do substantial revisions. You needed to make substantial revisions to this journal article before it could be published. And there was questions about the methodology used as well.
Am I remembering right, though, that this is the one where in the end the promotion was denied because it was late?
Yes, Your Honor.
So that's a little weird, right?
So, sorry, I'm sorry, Your Honor, if you weren't
just respond to my thought that it seems a little weird that all of a sudden, after months and months and months of this, it turns out actually it was late all along, but maybe not.
So, Your Honor, in this circumstance, the initial promotion was reviewed on its merit basis. So the first departmental committee had made the determination 2-1 to recommend for promotion. Dean Prime agreed with the chair of that departmental committee, Dr. Whitney Johnson, and said, you know, I don't think that the research is sufficient at this point. It went to the school committee. The school committee said 5-0. We agree that she is not ready for tenure and promotion at this point. Ultimately, the school gave her the opportunity to defer by 1 year. And after that offer was made, Dr. David Wilson, the president of the university, made the same offer. He said, you can apply next year. If you don't apply by next year, your employment with the university is finished. At that point, the appeal had occurred. And during that appeal process, more members looked at the occurrences that happened during this application, and they said, you know what, there were no issues with how it was handled at the lower level, but ultimately, when this appeal was happening, because there were a lot of communications back and forth, even though the appeals committee recommended that the promotion be denied because there were no irregularities, ultimately, the school at that point had determined there was another issue that we didn't catch before. And yes, it would have been great for them to have seen it on the front end, but ultimately, just because it wasn't addressed on the front end doesn't mean...
And the review committee, there's a lot of pieces here, but that's also the committee that said, we know you didn't get a letter reappointing you, but you should have. Is that the same committee?
Yes, Your Honor.
Okay, so there are some irregularities here, it's fair to say.
Your Honor, I think that the irregularities have to be tied to a discriminatory...
I'm just saying there were some irregularities
Sure,
here.
Your Honor. There were some issues where the procedure wasn't followed perfectly. But when we're looking at how the procedure was carried out, we have to consider whether that the irregularities were in any way related to any discriminatory animus. Here, all we have is the statement from Dr. Prime, but all of these irregularities or departures from the procedure that appellant has pointed out have been from other parts of the procedure process.
Okay, and then suddenly, I just want to make sure, because you're running out of time, now she's an at-will employee?
Yes, Your Honor.
That's also irregular too, right?
Yeah, very briefly, she was an at-will employee. The the university immediately said, but we'd like for you to now apply for that second 3-year term.
Okay.
And as soon as that application was fully submitted, because she did go on a period of leave, as soon as the application was submitted, it was accepted and she was given that second year.
I just want to ask you about the at-will employee thing. That comes 3 months after her EEO complaints, right? She suddenly turns into an at-will employee?
Yes, Your Honor.
Okay, how is this not a jury question on retaliation? 3 months after she complains, all of a sudden, she's made an at-will employee for reasons that seem to be a little bit irregular. How does a jury not get to consider whether the fact that she is made an at-will employee, and apparently first time ever, might be related to those complaints?
Well, Your Honor, I think that because of the temporal proximity, the distance in
I know,
time.
I agree that it's on the edge for an inference, but we have cases at 3 months, and it's not just the 3 months when she becomes an at-will employee. Almost, I think it's like days afterwards, suddenly, this appeal committee where this has just been sitting with nothing happening, suddenly they kick into gear to deny the appeal. And I think a reasonable jury could say, yeah, that's the first preparatory step. If you're gonna retaliate by making her an at-will employee, the first thing you need to do is like clear up this appeal.
Well, Your Honor, if I may briefly respond, I do know I'm out of time.
Go ahead.
In this occurrence, the school committee, or I'm sorry, the appeal committee was on summer vacation. It was dealt with in September, early September of 2017. A couple weeks prior, Dean Gibson had sent Dr. Hollis a notice that this committee was going to be assembled, and at that point, the school already had noticed that Dr. Hollis was bringing allegations against the school, because earlier, as a part of her appeal, when she first submitted that letter in May of 2017, she had already raised these issues. It wasn't a new occurrence or a new thought at that point. She had already made those allegations.
Okay, so, all right. Okay.
All right. Do you
I
have-
got one
Yeah.
question, I'm sorry. You haven't been arguing this way, and I appreciate it, but the district court ruled at summary judgment on the 2016 claim that it failed to, that there was a failure at the prima facie case. Your briefing and your argument today seems less prima facie-ish and more about whether or not you think there's a genuine disputed material fact on the basic statutory requirement of discrimination. Do you agree that prima facie really doesn't have anything to do with a summary judgment decision, that we should, that's irrelevant once you get to summary judgment?
Your Honor, my understanding is that the prima facie case is relevant at the summary judgment standard. It's just that the ultimate question still has to be answered under Title VII, whether it was a result of discrimination. So I think it's, from my understanding, it's a joint assessment between those two ideas.
All right, I appreciate that, thank you.
All right, I think we're at rest here as far as you're concerned.
Thank you, Your Honors.
And we have some rebuttal. You have 4 minutes, Ms. Wang.
Thank you. I just have 3 quick points. First, on the additional claims that were dismissed with the merits of her 2019 and 2020 claims, we briefed her Section 1983 claims on page 54 of our opening brief, which are not subject to exhaustion, and we appealed from a final order, which may be erroneously final, but which clearly rejected all of her claims. So this court does have jurisdiction, although the district court may have erred in dismissing some of the claims. And then second, on Dr. Prime's statements, opposing counsel is now pointing to the fact that Dr. Prime provided a positive review from Dr. Hollis's initial first-year packet, but this only makes clear that Dr. Prime did in fact receive Dr. Hollis's first-year packet and apparently reacted favorably, and yet that is also the basis for them claiming that her application for promotion in 2016 was untimely because she apparently didn't submit applications to be renewed. But when she resubmitted those applications later, they then told her she had been renewed, and that was after they had already demoted her to at-will status. And third, opposing counsel raises here factual disputes about Dr. Hollis's qualifications, which alone is a reason why summary judgment is inappropriate. But even if these factual disputes would be something that is difficult for a jury to determine whether a professor is actually qualified for a role, there's certainly sufficient evidence for a jury to determine here that MSU's proffered justifications are pretextual, given the procedural irregularities, their shifting justifications, and the fact that female professors were the only candidates who were denied or deferred in promotion applications while all these male comparators were promoted. If there are no further questions, I would just ask the court to reverse and remand on each of Dr. Hollis's claims.
All right, thank you. We'll come down and greet counsel and adjourn court for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.